Let's say by definition, item number 45, Lordship.
45.
Due to personal difficulties of my senior, matter may be adjourned for the day, Lordship.
Hmm?
Matter may be adjourned for the day. CD is available, Lordship. That may be retained, Lordship.
When do you want it?
So any dates next week.
Next week. At the Learned Council, at the request of the Learned Council for the
Petition.
petitioner, comma, the this matter will be listed on the next week.
Monday.
Full stop. Huh?
Monday.
On 15th of December, the Learned APP has submitted that the CD has been received. Yes.
Obliged, Lordship.
It has been submitted by the Learned Council appearing for the petitioners. For the you are for the petitioners? Which is the third matter which is listed before? What is the petition number? What is the petition number? Four zero nine and Mr. Singh. We'll just adjourn the matters. You make a mention there to have these matters tagged along with that. I cannot direct a matter to be, which is listed before court number 13. I cannot direct that it should be listed with you. It's all right. No, you have to make a mention there that these matters are also to be tagged with that matter. I cannot pass it. He has understood. Ask him. Yes, the Learned Council appearing for the parties are at consent that these matters are required to be taken up along with criminal petition number 409 of 2022 and 650 of 650 of 2022 full stop. The Learned Councils have prayed that these matters may be adjourned for the day so that all the matters can be listed together. Full stop accordingly. List these matters in the second week of January. In the second week of January. Full stop. You are appearing for whom in those matters? The name of learned senior advocate, Mr. P.J. Saikia, be reflected in the cause list.
I beg to mention item number 19, madam.
19. Yes.
But I am for the petitioner, my lord. There are some developments in this case, my lord. So I pray that this matter may come up after 2 weeks.
At the request of the Learned Council appearing for the petitioner, let these matters be listed on
After 2 weeks.
after 2 weeks. After 2 weeks on a date to be fixed by the registry. Learned Council for the Mr. So-and-so Learned Council is present for the respondents. We are saying after 2 weeks on a date to be fixed by registry. You move an application there.
My lord, I have one another prayer, my lord. I pray for listing of one regular bail application for motion, my lord. One similar matter is listed tomorrow, arising out of the same case diary. my lord.
Yes.
All right.
Allow. 18. Yes. TCI is received, I suppose. I think we'll have it next week. At the request of the Learned Council appearing for the petitioner, which is not objected to by the Learned APP. This matters again on the next week.
Made pizza, Lordship.
So I wish to mention item number 57 also.
57.
Hearing matter also.
Ah,
With the consent of Lordship, Lordship, there is a matrimonial appeal pending between the same parties, being met appeal number 75 of 2025, which is supposed to be listed in the month of January, Lordship. Let the matter come out after, in the month of February, Lordship, because there is a possibility of an amicable settlement between the parties, Lordship, in the matrimonial appeal.
respondents who appears?
Response, Lordship, I have taken informed Lordship, but she is not available. If Lordship taken up after, so in her presence, Lordship want to please.
We'll take it up as the matter is called up, huh?
Yes, Lordship.
Wait, please, your lordship, lordship, I beg to mention item number 23, your lordship. CD has not come, your lord.
Mr. Parashar?
And it will be taken after the winter vacation.
Let us have his. Mr. So appears for the petitioner. Learned APP has submitted that the CD is yet to be received. Accordingly, list this matter again on
Lordship, can it be on 8th of January?
8th of January, 8th of January.
Obliged, lordship.
Yes? Mr. Learned Counsel appearing for the respondents. With the consent of the Learned Counsel for the petitioner has prayed that this matter may be listed on next week, Rakhi Bodhan. 16th of December.
May I plead to Lordship? Lordship, I wish to mention item number 31, Lordship. She did not receive.
Just a minute. Not received, na? हाँ वो CD not receive वाला कर दीजिए. When do you want, when can we have it, Mr. Parashar? 18th? Huh? So and so appears for the petitioner. PP has submitted that CD is yet to be received. List on 18th. Huh? Yes? 34. Ms. Swensson and counsel appearing for the NCB has submitted that they would like to file an objection. Full stop. Learned counsel for the petition does not object.
On Monday,
List this matter again on
Tuesday, sir.
on Tuesday. 16 December 2025. Yes.
Right.
62. Huh. Call for objection is equal for call for.
Item 59.
Yes, we were completing the judgment, but we wanted a certain clarification. You were referring to the arbitration clause, sir. Can we have that clause for a moment? 60? Now, if we come to 63. Where is that? 63(1). If we come to page 72. Of the contractor's representation, make and notify decision on all matters referred to by the contractor in writing. Right? We find that this sentence, the top line, I'm reading the top line. A contractor in writing, there, what we understand is if we read a full stop there, otherwise the sentence does not make sense. Or even if we don't read it so, provided that matters for which provision has been made in clause 8, 18, so and so towards the end, if you find 61(1), 61(2), and 62(1) of standard conditions of contract or any clause stated of these special conditions of contract shall be deemed to be accepted matters. So if something is done in 62(1), it becomes an accepted matter. Then the next words, matters not arbitrable. So your order which was passed under clause 62 is not arbitrable. Just tell us that.
For 62, my lord, order of termination was issued.
Hmm.
Now, here in this matter, the termination order is again is final utility.
Hmm.
Because subsequently the work was allotted to someone else and that person has already completed the work. Now, here the dispute is with regard to my lord, refund of the amount that has been forfeited. So
That-
what
that-
comes back on 62.
That matter can only, that matter can only be decided if and when we decide whether the termination is correct or not. That has to be decided first. And if we have to decide the termination, whichever way we hold it, it is not a matter which can be arbitrable, which is arbitrable.
Yes.
So we will have to decide the termination. In case we find the termination correct, nothing remains. In case we find the termination to be not correct, since the work has already been done by someone else, the only other relief is what flows from a wrongful termination, barring compensation which this court is not deciding.
Yes, my lord.
So I just wanted that clarification that are we on the same page or not, that 62(1) matters are not arbitrable. Ah. At infant, yeah, we will keep in mind your submission on that. That the termination is. Huh. Termination has attained. Otherwise, we were on a mood to give the judgment yesterday. But Sunday evening, we found that, okay, we did not, perhaps I felt,
Yes, rightly point out.
I felt that we did not discuss this issue,
Yes.
whether 62(1) would be arbitrable or not. Huh. Because the first paragraph of the affidavit in opposition I have to deal with, the arbitration part. The rest of it is, we have noted your, this thing, the termination part. You should have it by tomorrow, maybe day after tomorrow. Hi, it'll come in the list, since it's a CAB matter, it has to come on the list.
Oblige, my lord.
Daily list, item 1. For a TT application, Lordship,
Hmm.
I was arrested on 14/11/2025. Today is about 24 days, Lordship.
Huh?
24 days, Lordship.
Hmm.
He was arrested under section 130(25) CGST Act. So allegation against him is that Lordship, he has at page number 11.
Yes.
He runs some farms, Lordship, and then in fake GST, Lordship.
Hmm.
But Lordship, as per as the petitioner stated that Lordship, these farms are not in his name, Lordship.
Hmm.
He's neither the owner nor he runs this, the Lordship. He is the only person who is a ordinary person, Lordship. He has a business of battery scrap. Is a by profession battery scrap, Lordship. So these farms are not in his name, Lordship.
Hmm.
So he's inside the jail, and all this matter is based on the documentary evidence, Lordship. All the documents seized by the arresting authority, Lordship, and he is inside the jail for about 24 days, Lordship. And here, Lordship, as per punishment, Lordship, 5 years is maximum punishment. 5 years is maximum punishment, Lordship. Paragraph 16 of it, there is a mention of the petitioner.
These bank accounts are not in your name.
No, lordship, nothing is.
In this case, it was in his name, yes. Hmm.
এখন ভুলে গেলাম, নাই, এখানে approve নাই।
Hmm. Hmm. Ah, yes.
But whether lordship, is these farms were in my name? Whether I run that farm, whether I.
That is one major difference we find in these two cases. Number one. Number two, kindly tell us that you had him arrested on 14/11. You prayed for a judicial remand for 14 days. Fine. So now once you had them in your judicial custody, you have interrogated them, you have all the documents with you. True. Huh. Huh. No, the tax evasion is on the allegation is on these, on both the petitioner. Now, you had 14 days from 4/11.
4/11,
November is gone.
14/11.
November is gone. December is in the midway. If you have not been able to take up all the evidences that you need and all the statements that you wanted by this time, how much further? Huh? That is the difference we are finding. This court had observed in that order, this court has observed that all the bank accounts are in his name and he has taken a plea. I have forgotten my bank account. What about this? Huh? We'll call for the case diary.
My lord, it's from Guwahati lordship, can you be fixed this week lordship, tomorrow or day
This
after
week
tomorrow?
is
Tomorrow, day after tomorrow?
This week is 2-3 days, huh? On 15th, we'll have it on 15th.
15th.
Heard Miss so-and-so and counsel is paying for the petition. I also heard Mr. S.C. Kiel, standing counsel in the standing counsel. GST, who appears, CGST, who appears on advance notice, good stuff. Call for the case diary. List again on 15th 15th of December 2025. Okay.
No, my lord, thing is that if that.
Same
bench
case
is-
diary hole to
That
assign
bench-
notification. I remember that.
he-
Same case diary.
No, my lord-
Petitioner. Not same case diary.
Oh.
Notification from Uliat Hobson. And you take down one more sentence. The counsel for Mr. KL has submitted that as per the notification, comma, this matter is required to be listed before the same bench, which had already considered the case of a similarly situated person with regard to the same case number, with regard to the same offense. Huh? Huh?
But that bench is not
Agile hai na?
the special cases lordship. Special matters is not taken. up.
No, full stop. Registry to verify and list accordingly. They'll verify and list accordingly. If they find that it is not, if they are not taking up the bench, I can take up the bench. We'll take it up. No difficulty.
But in this case, lordship, what happened, all the documents is in online. They can collect all these things, lordship. It is in online, lords. All the.
Madam,
Online
we are doing our best to have the limitation, the limit of custody brought to a minimum. But if you do not take care of his objections,
Oblige.
it will not be appropriate. কি লাগিব? এখন ঘূৰাই দি দিব দেই। এই প্ৰথম নহয়, এইটো মানে সেই মেনশ্যন কৰিছিলে যে। মোক নালাগে। Yes, sir.
Sheeted metal lordship, NDPS commercial quantity.
Heard Mr. So-and-so and council appearing for this so-and-so. Petitioner also heard Mr. K.K. Parashar. This is an application for okay. The two filed by two petitioners, comma, praying for grant of bail under section 483 of the BNSS 2023 in connection with from page 1, huh? So and so. Ah, no, it is there. I'm telling him, take from page 1. Call for the scan copy of the CD. List again on 7th of January.
Vacation lordship any date.
Full commercial quantity, will have to allow them some time to have their investigation. When were you arrested?
Sheeted case.
Huh?
Sheeted case, sir.
When were you arrested? In custody since?
Arrested on 20th July. Violation is the lordship 4748.
7th of January. Call for the scan copy of the TCR, huh?
Free.
You are good enough. POCSO notice has to go, we can't do anything today. Anything special that you want to, your senior would say? Any special circumstances? Huh?
He has been arrested since 15/7/2000.
Son of a. Hmm? Guard? Trial is going on, yes.
He is in jail lordship since 15/7/2025 lordship. Mandatory period is over lordship.
Oh, charge sheet trial is going on. Where is the question of a mandatory period, madam, here? Huh? Okay, she wants her senior to appeal. Yes, all official material. Yes,
Lordship 483 application, Lordship. Lordship petitioner arrested on 23/10/2020.
2310. What is the allegation?
Allegation under section 137(2), 1152, 55, 64, 2M, 3082, 351,
Educational School City Episode.
BNS. This is also
We'll call up. Hmm. Why through VC he was produced? He was produced through VC before the CGM Lakhimpur? Huh? No, it is, from what we understand is his first production is on VC. How does the magistrate find out from the demeanor whether he is hurt, he is terrified? He has been put under some pressure. This is nothing to do with the bail, but the first production, when the police have arrested him on VC. Huh? Otherwise, VC is allowed. We do not have any qualms on that during investigation, during trial, whatever. But the first production before a magistrate, then the very issue of a nearest magistrate goes. Immediately on arrest, he is to be produced before a magistrate immediately. Is it not? So then this VC, would VC suffice? 22, huh? 2410 he's produced through VC. So he's produced for the first time through VC. Is it, will it not be? But the first paragraph of the petition is saying through VC. That is what I'm saying. The accused may be seen on VC, sir, on what you see on camera is perhaps not what may be the fact on ground. Later on productions, we do not have any production through VC on the first occasion. Kindly have a discussion. We do not think that will be appropriate. Otherwise, the very purpose of producing a person before the nearest magistrate, tomorrow in NDPS case, they'll start through VC. Is it not? The first production before the magistrate is to see that the arrested person has not been harassed. He is in a position to talk to a person who's neutral. VC perhaps will not suffice. Yes, call for the heard Mr. So-and-so and counsel. Paying for the petition also heard Mr. KK Parashar and APP. This application under section 483 of the BNSS is praying for releasing the petitioner on bail who was arrested on 23/10/2025 in connection with Laluk PS case number so-and-so. Read with full stop this the offenses alleged involved provisions of the POCSO Act, full stop, in view of the above. Issue notice to the respondent number 2 in accordance with the notifications prevalent, full stop. Call for the scan copy of the case diary. No. He says it is forwarded to the special judge post POCSO. Call for the CD. Yes. Respondent number 2 has to be served notice. We'll have it in January. 18th of December. Huh? 18th is almost the last day. We'll also have to keep the board open for some new cases. We can't fill it up with. Huh?
19.
January. Earliest in January, what day can you have? 6th of January. Yes.
Fine. Offensive under section 4 of POCSO Act.
15/9. Same. POCSO Act, notice to respondent number 2, prevalent notification. Call for the CD. No, it says Doboka PS case number. Has it been charged? It has to go before that court. It has to go before that court. আগৰটো যিজনে কৰিছে তেওঁ তাতে যাব same FIR and তেওঁ আগতে ডিসপোজ কৰিছে ন তাতে যাব সেইটো কাৰণে তেওঁ চাগে FIR নম্বৰটো কিবা এটা 1-2 বদলাই দিছে নহলে ইয়াত নাহিলে হয় কিবা এটা বদলাই yes Would you like to go and try your luck there first? Charge sheet has been submitted. Try your luck there. Huh?
There it has been rejected.
Where? Show us.
Case 12.
Special just that, but special the case number is not there. In connection with
Heard Mr. So-and-so, also heard Mr. So-and-so on PP. Bail application praying for bail in connection with Duboga PS case number 179 of 2025 under section 4 of the POCSO Act. Full stop. Perusal of the records of the documents annexed with the petition shows that the charge sheet in the instant case has been submitted and the bail petition was thereafter rejected. Full stop. Call for the scan copy from the Court of Special Judge Ujai. Notice to the respondent number 2 in accordance with the prevalent notification. List on. We will keep the dates to your choice unless the petitioner's object. You keep a date. You keep your board ready.
6.
Hmm. Huh?
Special case number, my lord, also we have.
Here you will give a,
This year maybe call.
where do we find that special case number?
No, no, because first.
First page.
Sessions is special case number. That's also.
So and call for
Pending
the,
report
call
of
for the
special
scan
judge
copy of the
POCSO.
records from Special Judge POCSO Kamrup Metro, huh? Yes. Notice to the respondent number 2. In all POCSO cases, you keep the sentence. Even if I miss it out, you keep that sentence all the time. Notice to the respondent number 2. As per prevalent notifications, huh? 6th of January. List again on 6th of January.
Wait, actually, the complaint petition is at page number 11. It's a
Page number?
11.
Ah,
The custom case, Lordship, some 250 grams of heroin has been seized by the airport authority. And
how many grams?
250 grams,
Two
Lordship, is
five.
commercial quantity.
Ah,
2540 grams.
Yes. We'll call for the
CD maybe
CD,
for-
huh? Heard Mr. So-and-so and a council appearing for the petitioner, also heard Mr. So-and-so and a council appearing for the Customs Department, full stop. This is a prayer, this is a petition praying for consideration of bail under section 483 of the BNSS in connection with customs case number at page so-and-so, है ना? Petitioner has been stated to be in custody from 24/9/2025. Full stop. Call for the CD. List again on. Next week. 17 দিব পাৰি নেকি? 17th.
Lordship.
See, I am behind bars since 90 days. The FIR is page 11. I am a e-rickshaw driver. The police conducts raid at my, they stop me, they conduct raid, and behind my rickshaw, they found illicit substance violence. Later on, they booked me.
In your rickshaw.
Yes, Your Lordship.
Or-
Rickshaw. In my rickshaw,
Huh.
behind the seats.
Huh.
Now, after that, they booked me under 21 B, read with 27A.
Huh.
Later on, we find that the quantity is not a intermediate quantity, it's a small quantity. Now, Your Lordship will come to
Where do we find this small quantity part?
page 32, Your Lordship. When it
32.
is produced before learned magistrate,
Hmm.
page 32. So there are 6 samples, and if you calculate all, we have to minus 32 grams from each. Total is 4.64 grams. Yes. Please come to page, yeah. Page 29, please come to page 20. Page 21, the weight of, the law
Of
is
samples.
from, if there are 6 bales, from, if each quantity of each bale is below 6 gram, then all the, all the substance has to be put and it has to be weighted. All of this has been clarified from page 28, Your Lordship. That's the law. There's a 3-page order.
Yes, page 28, Mr. Parashar. If we have page 28,
28, Your Lordship. as per the law, at the third paragraph.
The third paragraph, weight of vials containing the suspected heroin and marked as A1 so and so.
Now, out of the, if we,
Huh? These are the vials if we remove the vials, है ना?
so now
है ना?
it's from each,
Or if we have the earlier page 27. Suspected heroin vial marked from A to 6. Gross weight of A to 6 is 10.58 grams. Gross weight with vials is 10.58 grams. So even then it comes, it will come down.
total is balance, if we cancel the weight of the plastic bag, it's 4.64 grams.
4.64 grams.
22A, 21A,
Hmm.
small quantity, it's a bailable offence. So what they have done, what the investigation officer has done, since it's they have booked me under 27A. Now let's say, we'll come to page, we'll
Where
come
is the
to-
Caesar list?
Yeah, now we'll come to the forwarding, page 19.
Where is the Caesar list? Show us the Caesar list.
Usually this I have not. opened.
What have they recovered from you? What all have they recovered from you? Mhm. Yes, page 16, Mr. Parashar. Page 16, 6 numbers of plastic container, 1 Vivo Android phone and 1 Bajaj RE. No money, nothing recovered from you. 27A, will it come in?
Now we'll also will come to charge.
Small quantity, 27A not there.
Charge sheet,
Where is the charge sheet?
page 40.
Page 40.
Not an iota of mention of the 27 ingredients of 27.
Six vials, he had the preparation for a week for himself, apparently.
And
Huh?
now-
Not to sell.
Now it should come to page 37, the list of witnesses.
What do you say? Huh? Even in trial, he may come out as a abuser.
There's no,
Page 37,
no, there are 5 witnesses.
SI of police. Who is Moinul Haq?
Moyun is Caesar witness. The 2 are Caesar witness.
Huh?
And then when Bonostri Deka is a scientific officer.
So,
And then 5 and 6 are investigative officer.
huh. How many
There is
independent?
no independent witness
Of what?
of 27A. All these are their state witnesses.
27 is financing.
Financing.
So no one would be seeing you financing anything. That will be done on your Paytm. You are granting it, Mr. Parashar? Looking at the quantity, the absence of any materials recovered to indicate 27A and oh, huh? Yes, bail granted 15,000 to sureties of the like amount. Subject to the satisfaction of the
Then it's special judge Hojai.
Ujai, huh? So this will be 21. He says it should be under 21A and we do not find 27A to be applicable, all right? Detailed order will pass in the chamber.
Much obliged.
Yes,
Petition Lordship.
disposed.
Lordship, where did you petition Lordship? The petitioner inside the jail from 224 days
Hmm.
and no such sheet has been submitted, Lordship.
For doing what? No charge sheet, 221 days.
Such sheet has not been submitted. No,
Huh?
yeah,
When should we have it listed? After 220 days. Hmm. One 80 days, yes. So,
another thing, Your Lordship. It is not a matter of 22C, Your Lordship. Similar than the previous matter. It's a matter
Huh?
of small quantity. What is the maximum?
Which is this bail order you have annexed?
Yes, yes.
Of whom?
The co-accuser. The co-accused was released on bail.
Same case, same PS. Same FIR. Yes, Mr. Parashar, same FIR, it has to go before that court.
Yes. This is what it's a, it's a district court, court order, Your Lordship. After granting bail to the co-accused by this honorable court,
Hmm.
I approached the honorable district judge
Hmm.
where my bail
It has to
petition
go,
was
no?
rejected.
He just get a reason. Anjan Kolita, pending. One is pending. It is disposed. No. Are you pending? Two similar cases are pending, two connected cases are pending on the same FIR.
No, one is pending, one is disposed of, Your Lordship.
There are three cases, sir. What is your name? Abu
The
Amatu.
anticipated
Etu Amatu.
AB is pending, Your Lordship.
If one AB is pending.
AB is pending, and on the last occasion, Your Lordship, it was posted on 2/12,
Hmm.
where the updated CD was called for, which is available, and no such is submitted. I have the order. The updated CD was there. And Your Lordship may kindly come to the page 14, Your Lordship. That's for me.
What? How much? Today itself. We'll have it at two.
All right.
Let him have, give him the documents you are trying to
Yes.
rely upon. Let him have his
All right.
instructions. At 2 money. Yes, sir. Meet him at 1 o'clock. Another person is waiting for you.
Yes.
Yes. What is the offense is under T03 of the two, T17 of
Ah,
T17 of two. The Indian Gorchuk PS case, the person was arrested on 19/11/2025. My name is not in the FIR. I've been arrested, the statement given by one of the two accused. And two cylinders recovered from my restaurant, where I am not the owner of.
hmm?
Lots of gas cylinder recovered from name is given there in the FIR, but my name is not there.
You are from BD store or
No.
Mass General Store. You are neither.
I am not from the any store which are mentioned in the FIR. Case 15, last night. Case 15, Jonathan Perez, Rasul. All the leading and shown the arrested business person Nikhil Boro. Total 3 numbers of students in the way recovered from the position of arrested students, serial number to Sokol. Yes, Lordship, that is true, but it is not reflecting that it is basically I am working as an employee in a restaurant. And the cylinders are recovered from the restaurant. But surprisingly, the owner has not been arrested. When the police visited the restaurant, I was there, they had picked up me.
Owned by Minal Dekar. BD store. 3 stolen cylinders from Ma General Store, Nalapara. Near Greenland instance where 8 numbers of, in total 11 gas cylinders were recovered from the above mentioned stores. Accordingly, 3 persons. 3 persons are Manoj Boro, Minal Deka, and Manoj Kumar Shah were apprehended and brought to Gorchuk for taking instruction. On lead and shown of arrest accused serial number 1 Nitul Boro. Total team were recovered and from the possession of arrested accused serial number 2. But why does the brief of the case does not refer to anything recovered from page 19?
No, it is an order passed by the learned magistrate court. Yes.
No, what we are looking at is This brief of the case is page 15. Recovery is shown from 3 houses. You see, BD store by Mrinal Deka, owned by Mrinal Deka. Where do you work? Which of these 3?
No, I am not working there. I am working in a separate restaurant.
What is the name?
Ma Kali restaurant.
Ma Kali restaurant.
Nothing is
Okay.
recovered from the Ma Kali restaurant.
Now we have Mrinal Deka, BD store, Ma General Store, Nalapara Bosistho. Where H and two. So from two locations, 11 cylinders. Manoj Boro, Mrinal Deka and Manoj Kumar Sai arrested. Yes. 3 cylinders apparently is from BD store, Mrinal Deka, and Mrinal Deka is also arrested at serial number 2. Accordingly, all 3 persons were apprehended and brought to Gorchuk. How does Bhumik come in?
Almost 1 month.
Huh? Huh?
1 month and it's a crime. It is not a heinous crime. So I think
So we can.
just keep it out there. Without the help of some veteran only, maybe household they cannot pay. They have used.
Domestic cylinders, they steadily used it. No, that is one part, but if your brief story does not, brief history of the case does not show that it was recovered from him, maybe this Mrinal Deka, is Mrinal Deka arrested?
Yes.
How many arrested persons? Where can I find? Yes, 4. Manoj Kumar Shah, Mrinal Deka, and Hiranyo Buru. What is your name?
My name is Jain.
Shankar Bhumik.
Page number 16.
Subsequent arrests. So Shankar Bhumik may have been traced out later on also.
Lordship, I submit one thing that my ground of arrest is when they arrested these people, this Nipul Bora disclosed that he has sold out 2 cylinders to the owner of the restaurant where I am working as an employee. Accordingly, police visited this restaurant and they recovered 2 cylinders. At that time, I was sitting in the restaurant and they have arrested. But surprisingly, they did not file any FIR and nothing has been done against the owner of the restaurant.
Where have you stated, where do you work? Where do you find that Ma Kali restaurant?
Akali restaurant's name is mentioned nowhere in the FIR, neither in the forwarding report.
Eh? Well, okay, heard Mr. So-and-so and council paying for so-and-so. Also heard Mr. K.K. Parashalan at PP. This is a bail application under section 483 of the we'll go by the records. We need the CD or not, Mr. Parashar? Huh? Don't need the CD. Application 483 BNSS in connection with Gorchuk PS case number 306 of 2025. under section 303 within bracket 2 and 317 within bracket 2 of BNS 2023 full stop, the petitioner has been in custody from 19/11/2025 full stop. The allegation against the petitioner is, the allegation as reflected in the FIR dated 12/11/2025 is that the police personnel had pursued one Manoj Boro, who had attempted to flee upon seeing a patrolling party, and thereafter, on his apprehension, he admitted to having stolen gas cylinders and other household articles from various locations under Gorchuk PS jurisdiction and selling them to different stores. Full stop. As per the information, comma, 11 stolen gas cylinders were recovered from one BD store and one Ma General store, and 3 persons, Manoj Boro, Mrinal Deka, and Manoj Kumar Shah, were apprehended and brought to Gorchuk police station for necessary legal action. Full stop. They were accordingly arrested and forwarded to the court of the learned remand magistrate on 13/11/2025. Full stop. The petitioner herein had been arrested on 19/11/2025 and on the grounds of arrest shown in the remand petition, comma, the arresting authority has stated that on the lead and shown arrest of accused serial number 1 Nitul Boro, comma, 3 numbers of stolen LPG cylinder were recovered from the possession of of the petitioner herein. Full stop. Mr. Swenson, under counsel appearing for the petitioner, has submitted that the petitioner herein is an employee in the Ma Kali restaurant, and although 3 cylinders had in fact been recovered from the said restaurant, comma, the forwarding report does not reflect the search and recovery in the Ma Kali restaurant. Full stop. He has submitted that the perusal of the forwarding report is a repetition of the earlier forwarding report, and the petitioner has been arrested without furnishing any details as to why he has been arrested. Full stop. We have gone through the records available and find that the petitioner has been in incarceration from 19/11/2025. Full stop. The forwarding report does not reflect as to how the arresting authority seeks to substantiate the involvement of the petitioner for his continued detention. Full stop. This is only a prima facie view on the materials available on record. Full stop. In the circumstances of this case, this court is of the opinion that the petitioner can be allowed the privilege of bail as prayed for. Full stop. Accordingly, the petitioner is directed to be released on bail. 10,000 to sureties like amount, subject to satisfaction of the CJM Kamrup. আৰু not to repeat অমুক দুটা আছে।
Item 3.
Wait, please, Your Lordship.
Yes,
There is
Mr.
a
Kumar.
complaint of Galib.
Huh?
Galib has said, इसने गालिब निकम्मा कर दिया वरना हम भी आदमी काम से। Well, the result is the Laila is in jail and Majnu is in jail and Laila is in chains. Your Lordship says last page.
Last page.
Yes. This is a photograph he has sent.
Hmm?
He has been confined in as a colored photograph.
Yes.
But there was a love affair between the,
What is this?
this is a photographs which she has sent to the mother of the petitioner. That she has been confined and
Who took the photograph?
her friend.
Acha.
Background is this love.
Hmm.
But the victim and the accused both are residents of nearby locality in Karimganj. And Lord, they had a love relation. And an FIR was filed, Lord, that your Lordship find at page 15.
Page 15.
Yes.
Yes. We were reading that.
Type copy as page 18, my Lord, translated.
On 16/5, accused number 1.
Lord, he has gone to Hyderabad, my Lord. Thereafter, he was arrested from there. He was brought to Karimganj. And my Lord, to kindly see page 38. The charge sheet has been filed in this case, my Lord. Page 38 is
Just a
the
minute.
statement of the victim.
Page
38,
38.
part of the charge sheet.
Yes.
Yes. And page 43, Lordship.
From 10 years of age.
But
He started on a very good note.
page 43, my Lord.
Uh-huh.
So your Lordship would see.
Yes.
This is a certificate obtained by the father of the victim
Hmm.
from Dimapur, my Lord.
Hmm.
He was born in Karimganj in 2006. He was a major, my Lord, that she has. But in these facts, my Lord, whether I am
When was the incident?
16.
16/5/25, Mr. Parashar. Birth certificate obtained on 22/7/15.
Otherwise, my Lord,
Huh?
only thing is, my Lord, 21.
Huh.
Maybe it is obtained in but FIR of 25.
Hmm. Which is in 23. Oh, this is 20. Oh, I thought it was
15.
25, 15.
15.
My
born,
bad, my bad.
Born in, my Lord, 8.
Hmm?
Born in 2008, it's showing.
Hmm. So,
No,
without-
what we say is, Lord, this has been obtained. This is a fake certificate.
24/12/2008, huh?
Yes, Lord, what we are alleging is,
Huh.
Lord, that she was born in Karimganj. This has been obtained. This is a fake certificate. Only to prima facie satisfy your lordship.
The courts are of the view that the Board of Secondary Education exam will have precedence over everything.
Lord,
Page 44.
Lord, this certificate is the basis for page 44.
Whatever.
If the initial is, Lord, I am trying to satisfy your lordship on a prima facie case, Lord, that I am not entitled to be in custody.
No, what?
And notice has to go, Lord, at this stage, because
That is what we had said in the morning. We go for a notice, we'll decide it once we have
can I
something.
pray, Lord? Can it be taken on 18th, Lord? I'll take a chance, Lord, it can be served.
18th we are overboard.
Lord, we'll try, Lord.
And the service of notice is
Lord,
also.
that, Lord, we'll take a chance, Lord. Without notice, Lord, not possible.
হেৰিখিনি দিব পক্সো স্পেচিয়েল কেছ স্পেচিয়েল সেশনস কেছ নাম্বাৰ 53 of 2025 হা Mr. Dube আৰু Mr. Hari steps on the respondent number 2 as per prevalent notification call for the scan copy 18th. Now he wants to take a chance. Let him have a chance. 18th.
More than 6 months, my lord.
Could it be 19th? Could it be 19th?
18, my lord, 19 will be last.
19th, 18th. I would-
Okay.
Yes. Mr. Chauhan.
Two petitioners, my lord, they
Hmm.
they in jail, my lord, for 228 days, 7.5 months.
Hmm.
My lord, they are facing trial, my lord, 3 witnesses already examined, my lord.
Huh?
3 witnesses already examined, my lord.
What kind of weapons have been recovered?
My lord, pistol, my lord. 1 pistol and ammunition, my lord.
Huh?
1 pistol and ammunition, my lord.
Oh.
My lord, out of 6 accused, my lord,
Huh?
1 already, my lord, granted bail. Kindly see, my lord, the page 30, order dated 24/9/25. All the accused on the same footing, my lord, and 1 is granted bail.
Yes, Mr. Parashar. Trial is on.
Sections are, my lord, certain, but that, my lord, a section of extortion, but my lord, there is nothing in the affair that they committed extortion of some persons.
Too many elephants in the area, they were carrying pistols with them. Why would a person carry pistol without a license?
That is for which, my lord, they are facing, my lord, that is imprisonment for up to 5 years, 5 years.
Can we have the stage of the trial? Huh?
My lord, 3, my lord, 3 PW examined, my lord, PW1, PW2 claim to be independent, my lord. They said that only police call them and they obtain their signature.
How many PWs?
PW, 12
Proposed?
PW, 12 PW cited, my lord. Out of 12, my lord, 7 police officers, police personnel. My lord, page 34, PW1, can you see what he said, my lord? His signature only obtained, no arms ammunition found to him. Page 34. And that too in the police station. And you see, my lord, cross path. And he claimed to be independentness. I do not know from where and from whom the arms ammunition were recovered. Police did not show me the arms and ammunition at the time of taking my signature. This type of, my lord.
What are your names?
Our
Go.
name is, my lord, Dawharo Bodo and Hosiar Bosumatari. PW2, my lord, on the same line. Can you see, my lord, page 36? Cross person, my lord. Police did not show me any arms and ammunition. They just took me my signature in the seizure list. Police also did not disclose about the seizure list. I also do not know from whom and where the said arms and ammunition, this type of, my lord, evidence. And third PW is, my lord, the complaint in the police officer.
Yes, sir. Seizure witness says I did not see these persons and the other says I did not see the weapons. Huh?
My lord, one already, my lord, granted bail.
What is his name?
My lord, his name is Loha Bosumatari, my lord, page 30.
Ah. Loha Botsumotari.
Page 30, my lord, second part, relevant person, page 31, my lord. Page 31, last 4-5 line, my lord.
page 31.
31, last 4-5 line, man.
Loha Bosumotari. Hmm. I do not know the facts of the instance.
Very long FIR and charge sheet also.
Yes, Loha, there is no evidence of such, when he was in possession by legal.
He was in possession. Where do you find it?
Carrying Loha, because there. Something also, if this Loha was on the contract of telling this,
Hmm.
there is no evidence such. He was in possession.
Hmm.
It is submission, my lord, it's submission. And my lord, 135 days, my lord, we are, my lord, 228 days. 7.5 months. Since 26 April 2025. And both the petitioner, my lord, local, my lord.
So, this Doharo Boro has some arms were recovered from him as per the statement of the
My lord, only
Seizing
one
officer.
people, my lord, are this
Hmm?
munition. And my lord, rest are my lord, mobile phone. No, 6% ignite accused.
Hmm. Now, Kenaram and Doharo, they have
Jawahar.
things have been recovered from him. Husiar Bosumotari, I think is similarly situated like Loha.
My lord,
Huh?
my lord.
Husiar you will find was arrested along with Loha, page 38. They were apprehended together
Yes, ma'am.
and arms was recovered only from Doharu and Kenaram. Hai So nothing recovered from Loha, who has been granted bail, and from Husiar, who is the second applicant.
My lord, arms, my lord, reportedly, my lord, kept somewhere. As per police version, my lord. And it was recovered from that person, my lord, village. FIR says so, my lord.
On point, my lord, page 23.
Yes. Hmm. Hmm. Hmm.
Eight line.
Hmm.
Still, the how would use here as a you the first word to here. Was then compared Daharo. He is deliberate attempt to evade situation, not to control, to change clearly shows the high level planning. The Daharo, with the help of the accused, also aim to recruit approximately 20 individuals, primarily used to form a group that could be armed with pain for carrying out female acts.
Hmm.
My
Huh?
lord,
Scan copy of the trial.
everything, my lord,
We'll
they
call
are
for the
nothing.
scan copy of the trial court records. Any further evidence has been recorded. We'll see.
My lord, scan copy, my lord, charge sheet is there, PW3 already examined, it is here, my lord.
We are not
FIR is
very
here.
convinced on Dawharo.
Yes.
Yes.
My lord,
Husiar, I do not know who. Husiar.
whatever, my lord, to be called scan copy, my lord, everything, my lord, I have an idea. But
Allegation is not only of one extortion, it's of
dependent two witnesses, yes, my lord, only our signature taken in the, my lord, seizure list.
Hmm.
And we don't know anything else.
You said the final extra to zero level, that is something like.
Well, they took from 7.5 months, my lord, they are in custody.
Let us call for the scan copy of the TCR, huh? Mr. S. Chauhan. Spencer, it has been submitted that an application under 483 of the DNSS with regard to Tongla PS case number so and so. The charge sheet in the instant case has been submitted. And and the trial is proceeding, full stop. The witness of three, as per the application, the statements of three of the witnesses have been taken, full stop. Learned APP calls for, prays for an opportunity to go through the scan copy of the TCR. Full stop list again on
My lord,
When?
16, 17, my lord.
17th of December. Call for the TCR from the concerned court, huh?
In 12.
Wait, please, Your Lordship.
Hmm.
Lordship, intermediate quantity, 121 days behind the bar. The statutory period is 60. The only reason behind the bar is 27A of the NDPS Act, Your Lordship. However, Your Lordship, in the FIR and the forwarding jointly read, there is not even a one single line which includes or implicates 27A, Your Lordship.
How much recovered?
14 grams, Your Lordship.
14 grams with vial, with vial.
With vials. And only
14
14
grams
grams
with
with
vial.
vials, no money. In the seizure list also nothing else, Your Lordship.
11 plastic vials. Total recovery 14 grams.
From the FIR and
Where is the forwarding?
forwarding is at page number 14, Your Lordship. In the grounds of arrest, reasons of arrest, brief of the case,
Page number
page number 14, Your Lordship.
14.
Nothing is mentioned about illicit trafficking of drugs or, Your Lordship, financing, Your Lordship.
OC sir had already authorized me to search the body of the accused. So I searched the body of the accused. Huh?
Indeed, Your Lordship.
Is that the manner?
Furthermore, Your Lordship, grounds are given 1 to 7. Nowhere it is mentioned with regards to 27A, Your Lordship.
Hmm?
Just to frustrate the process of law, Your Lordship, 21B, okay, Your Lordship, 14 grams, but already 121 days behind the bars, Your Lordship. The 60 days statutory period. The Charge sheet has not been submitted as on 12/11 is the last order. Your Lordship.
Hmm?
Upon last order was on 12th of November. It was rejected for the last time before the trial court, before the district court,
Hmm.
and therefore we have filed this bail application before this.
Hmm.
Charge sheet not submitted.
Arrested on 10th of August. Yes, where does 21A come in, sir? Fourteen grams with vials. That would come down to a very minimal quantity and also no recovery of money, anything. Huh? I don't think there is even a mobile phone recovered from him.
Nothing is recovered. He's a very poor person, Your Lordship, and
Nah.
that is the reason 120.
Why was he carrying this amount?
Your Lordship,
Very poor person.
social, going beyond law, if I submit socially, Your Lordship, just for the sake of money, Your Lordship. These are not peddlers also, and these are very poor citizens, Your Lordship. The virtue of being 120 days behind the bars, even after 60 days was completed, it implies, Your Lordship. Mostly an indigent person.
Yes, Mr. Parasar, tell us. Hmm. 27A. So if the 27A part is if you read the first paragraph of that order, page 21. The only ground it was objected was on 27A. No other grounds. 27 and nothing recovered to show that he has some proceeds of any. 15,000,
Deeply aware.
two sureties of the like amount
Deeply
to
aware.
the satisfaction of the,
District and session judge हो जाइए.
why district and session judge?
Deep.
Huh?
Special judge
Special judge.
in the court of special judge, Your Honor.
Oh. Any liquid video? 14 grams with vials. Grams with vials, no recovery of proceeds of business. Disposed.
Much deeply aware.
Pre-arrest bail application. The FIR is at page 27. The allegation is that based on some information not free, 3 vehicles were intercepted, suspected of carrying stolen coal. So thereafter, the vehicles were seized, drivers were arrested, and the drivers were subsequently were granted bail. Also, we are the owners of the vehicle. Also, Jimma is also been granted by the learned SDGM. Only my apprehension is that, Lordship,
Since you are the owner, you may be arrested.
yes, Lord, I am just for the order, Lordship, for taking the release of the vehicle, Lordship, I am before you.
Huh?
For taking the release of the vehicle.
If you
I'm
go to
no-
take
no
the
way
vehicle, they'll
linked
arrest
with the
you.
FIR, Lordship, I'm no way connected in this.
Maybe, because the knowledge of the owner of the driver is.
Cool.
Custodial detention, Lordship.
Huh? No, the trucks have been given on Zimma. Someone has to take the Zimma now. Huh? Tell us.
The co-accused, Lordship, has also been granted bail.
We'll call for the CD. We
Thank
keep you on interim, you go and have your statement recorded. Your CC has been submitted by me. This is an application. Under 482, seeking the privilege of pre-arrest bail in connection with Margherita PS case number 127 of 2025 under section so page number 1 ta ase, huh? Read with so. Full stop. The learned counsel for the petitioner has submitted that the petitioners are the owners of 3 vehicles which had been intercepted on the apprehension that they were carrying illegal coal without any valid document or permission. Full stop. The learned counsel for the petitioner submitted that the Zimma petitions for the aforesaid vehicles have been allowed and the drivers of the vehicles have also been released on bail. Full stop. The petitioner, the learned counsel for the petitioner submits that there is an apprehension that the petitioners may be arrested when they approach the authorities for taking Zimma of the vehicles and therefore this application for pre-arrest bail. Full stop. Call for the case diary. In the list again on so-and-so, 9th of January. In the meantime, the petitioners shall appear before the investigating officer within 7 days from today to have their statements recorded. In the case of their arrest, they shall be released on bail of 10,000 rupees subject to the satisfaction to 1 surety of the like amount subject to the satisfaction of the learned IO.
Deeply aware.
Disposed of, disposed of now. Interim. 9-1, list again on 9-1. Yes?
Anticipated bail application under 482 BNS. Lordship will find the FIR at page number 13.
Page number
13.
30.
13.
13.
May I read, Lordship?
With reference to the subject cited above, I have the honor to report that today, that is on 22/11/2025 at about 5:30 AM. And information has been received from a local villager of Samdang Tea Estate that one Bolero pickup bearing registration number so and so, loaded with stolen kettles entered in Samdang Tea Estate area. Accordingly, after receiving the information, self along with SIA so and so and staff proceeded towards Samdang Tea Estate. After reaching Samdang Tea Estate Itapata line, we have found the Bolero pickup vehicle
Huh.
bearing registration number so and so at the said place, wherein the said vehicle.
You are who?
My lordship, actually, I am neither the owner nor the driver, lordship.
Huh?
My name is only mentioned in the last line, lordship.
Huh?
Further, it is to be noted that once Sri Ratul Bora of Filobari is found involved in the said incident, who assists in transportation of stolen cattle since long habitually.
Huh?
This is the allegation.
Hmm.
The entire lordship cattle as well as the lordship the vehicle
Hmm.
has been seized. Lordship, at this stage, lordship, my custodial interrogation may not be required.
Since
Because of-
long? Since
Yes,
how
that is
long
the-
we
that
must
is the-
know?
That is the allegation, lordship.
Huh?
That is the allegation.
If it was a wallet, anybody's pocket, these are big cattle. The facilitation has to be there.
Lordship, the kettles have been.
CD
Lordship,
14, one Bolero, 14 cows
no, lordship, 11 cow.
and 3.
11. Lordship, the driver has been, lordship, arrested, lordship.
Huh?
And
So
Lordship, lordship, I am apprehending here
that
because
is
of
only
this.
one vehicle. If you are facilitating,
I will
there will
be-
be other vehicles around.
I will appear, lordship, before the IO, lordship. Lordship,
Hmm.
kindly consider, lordship. I will appear, lordship. Because everything has been seized, lordship, including the vehicle.
Hmm.
11 cattle have been seized, lordship.
Hmm.
And they are in the custody of the police, lordship. Lordship, may kindly consider, lordship. I will cooperate and record my statement, lordship.
Hmm? When? We'll have it. When? January 9th. 9th, 8th কেইটা দিব? এইখন হেৰাই যায় আৰু। Ninth of January, call for the CD. FIR is of 21st of November.
Lordship. 22nd.
Appear before the IO within 7 days. Interim 15,000. Huh? Interim 15,000, IO 7 days.
Keep the order.
9th of January, no? Yes,
For hearing, item 14 and 15.
for hearing.
Sorry, can be submitted.
Maybe close, my lord, sir. On the last occasion, your lordship was directed her to whether she is agreeing or not.
Huh?
Otherwise, my lord, the only my prayer is, my lord, it should be as per the master circular.
What was the issue?
That, my lord, I am engaged in the business of, my lord, manufacturing sleepers, railway
Hmm.
sleepers. So railway allotted us land,
Yes.
and initially there was no license fee.
Huh.
Subsequently, there is a license fee.
There was
So
one
what we are
judgment.
saying, that license fee can be taken as per the their master circular.
In case
It is
in case they want to proceed with coming into a new agreement with you,
Yes, I am agree.
that is one part. And in case you do not, then it's another
Yes,
part.
sir, that
What do you
it
say?
is their
Hmm.
If our case for 3-4 acres on them, there is a license.
Mm.
There shall be the existence. We have written them to,
Mm.
For another 7.09 acres, there was no.
That judgment will apply.
That part,
The judgment will apply. Now, what we wanted to know from you is whether even for the 8.3 acres, if they go for a renewal of the license, not a fresh license, a renewal of a license on the terms and conditions that you would have on them, on on mutual considerations. Hmm. Hmm. Huh. 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 No, no, we are, Ms. Sharma, we are not going to lay down the terms on which you would come to any agreement with them. What we wanted to see was whether there is a way out where for the portion of the land where you did not have any license agreement, you would, the parties would attend to go in for a fresh agreement as given in the judgment, whatever are the terms. For the portion of the land where they had an agreement was not renewed, can we leave it to the parties to sit down, find out if you can renew the license on the terms as applicable by the circulars? What would be applicable? Something has to be applicable. Then this cannot be closed. Then it cannot be closed.
This is the issue.
Then it cannot be closed. We have to hear it.
My learned friend is that, then your lordship hear the entire matter. I will set.
I understand. No, even she is bound. It
What
may
is
sound
it?
reasonable, logical. She may agree to it, not
What
agree
I
to
am
it, but
saying-
it is the
what I am
plans.
saying- See,
Huh.
My lord, as per the master circular,
Hmm.
because time and again I will show, my lord, we have written this, because this honorable court in the.
We will fix this in the month of January. We are taking up a criminal bench now. We cannot
Fine.
sway between the two. It will be we'll fix this in the month of January. What we wanted, if it could be done, which would then not require us to adjudicate to your detriment or to his detriment. If you could come, that judgment allows the creation of a license agreement. Can this be renewed? And if it is to be renewed, there has to be some give and take. He has to concede some part, you have to concede some part. That is upon you to do. Let's take down, heard Mr. Goyal, learned counsel appearing for the petitioner, also heard Ms. B. Sharma. Learned counsel appearing for the petitioner, this matter has been heard on at length on 2/12/2025 and was fixed today for further hearing. Full stop. This court is presently taking up another bench. And therefore, after some deliberations on the matter with the consent of the parties, let this matter be listed again in the month of January 2026 on a date to be fixed by the registry for further hearing.
Date may be fixed, it will
For further hearing. We cannot fix a date because we do not know when we are here and when we are not here.
keep yourself.
Further hearing কৰি থলো পাঠাত থাকি যাব আজি আকৌ এটা hearing কৰিলো হা
Time being, my lord.
The petitioner's case without considering ACP action fully done. In fact, one of the petitioners of the case in action.
along with the MSCP
Without
without MSCP ha
the MSCP, because they are entitled for MSCP or not.
ha
Why they have come?
they want the MSCP along with it. They were being paid the provisional pension in the meantime. Provisional pension they were getting. Their grievance is whether they should get the MSCP or not. You have finalized the pension now. You have finalized the pension now without the MSCP.
One, we have delivered.
Ha.
Yeah.
So since today this bench is taking up criminal matters, we would not like to go into the merits of this civil petition. Since they are processing it, you are having a provisional pension, we'll have it in the first week of February.
Oh.
Will that do? Okay. একেটাই order লিখিব. This matter by order dated 4/11/2025, this matter was required to be listed today with an observation that an attempt would be made to dispose of the repetition. Full stop. Today this court is taking up another bench. And therefore, with the consent of the parties, let this matter be again listed on the last week of January 2024-26 on a date to be fixed by the registry for consideration. Yes.
220.
My lord, this is against the order, sorry, judgment passed by the learned session judge Nalbari,
Hmm.
dated 29/8/2023 in criminal appeal number 23/22,
Hmm.
whereby acquitted the respondent from the charge of charge punishable under section 138 NI Act. My lord, in this case, the petitioner is a businessman, my lord, sorry, appellant is a businessman, and he is a owner of a shop, my lord, Popular Hardwares.
Mm.
And which is situated under Nalbari district, my lord.
Mm.
And the respondent is also a proprietor, my lord. He is the proprietor of a store, my lord, Messrs. R Associates, and he carries out contractual works, my lord.
Mm.
Both of them has good relation, my lord, and the respondent used to take materials from the appellant store, my lord, Popular Hardwares, and on good faith, he used to give him, my lord, supply him in those materials without any, my lord, payment, my lord, and ultimately it amounts to an 36 lakhs for 60,000.
Hmm.
And on several occasions, he requested him to pay the amount. And ultimately on 19/3/2019, he gave him a check where his signature was there, my lord. And on presentation, it was returned as the signature differs.
Signatures were?
Signature differs, my lord.
Okay.
Name-
Hmm.
Then.
Today
my-
we'll have to issue notice to the
Yes, my lord.
other side.
Ask them, my lord.
Yes. This criminal appeal has been preferred by the appellant. Is selling the judgment and order dated 38/2022. No, sorry, criminal, has
Judgment.
been passed, has been filed, is selling the order dated 29/8/2023, passed in criminal appeal case number 23/22 by the court of the session judge Nalbari, full stop. Issue notice. Mr. So-and-so appears for the, learned APP appears for the state. Notice on the respondent number 2 by usual process as well as speed post. List this matter again on. Speed post hole. February date. Huh? Speed post service report আহিব লাগে তো 19 জানুয়ারি না 20 জানুয়ারি হ্যাঁ 20 জানুয়ারি ও মোটামুটি 2 সপ্তাহ যাব না 4 সপ্তাহ হ্যাঁ on 20th of January
Obliged,
along with service report.
obliged, obliged.
M21.
May I please, your lordship. My lord, this petition file against the.
TCR কল কৰিব লাগিব নেকি নালাগে ন এতিয়া Yes.
My lord, this petition is filed against the, my lord, special case arising out of. Affair is page 18, my lord. But at the time of, my lord, the alleged victim was, my lord, 17 years, 4 months, 2 days at the time of marriage. Now she is, my lord, 21 years, more than 21 years, 2 months, today, my lord. And the petitioner is the husband. And 2 is the father-in-law of the, my lord, victim. That is the, my lord, the father of the petitioner number 1, my lord. Both are, my lord, the father and husband and the father, my lord. And it is a settled law, my lord, in already some similarly situated cases, my lord, the honorable court, my lord, quashed the, my lord, proceeding. I have annexed what judgment, my lord, in page.
Yes, you are.
And affidavit, my lord, she has filed no objection, page, my lord, 31. 32.
You are appearing for whom? Number two?
White, my lord.
What do you say? Huh? Mr. PP?
No,
Huh? Ah, folks. Similar cases. Cost
I have NX, my lord, NX, sir, my lord.
annexed. Yes, he
Second.
has also done
Yes,
done you a favor, annexed.
And page 34. And a PDB, my lord, page 32, where she, my lord, stated that, my lord, she has no objection. And page 32, page 32. 21 years,
Hmm.
21 years, 2 months, and
Hmm.
FIR stated that she is.
Have you seen page 37? Page 37. There is no possibility of conviction of anybody in the future. Huh? What do you say? We may go into an academic discourse, but what do you say? Laying down a different law and let bygones be bygones. What do you prefer? Yes. Hmm. True. The law not only acts as a punisher, it at times acts as a deterrent. The procedure of law. No, that was necessary. That is the entire intent. Punishment would. Heck, we have seen, was one case, it was a 12-year-old. This court had to, there are instances, if you are speaking of 17, we are speaking of 12 years old, healthy baby. Doctors refused to terminate. Court could not interfere. We've seen those instances. But here what to do? Let the candle burn for some more time and then in the month of March or February, no? The wife is here, the father-in-law is here, the husband is here. Yes. We'll allow it in terms of the early order. We'll record the facts, allow it in terms of the earlier order. Disposed of. Petition allowed. Huh? ইয়াতে এটা judgment এটা আছে পিছফালে এইটো ফলো কৰি ল'ব লাগিব চেম্বাৰ দি দিম মডিফিকেশ্যন disposed of allowed. Yes.
Your Lordship,
Ah.
this is an application under 528 of BNSS for setting aside order dated 17/9/25 passed by ADJ 3, thereby rejecting the custody of our mobile phones. Lordship, it's been 225 days since the seizure of our mobiles, and on last two several occasions, the investigating officer submits that it has been sent to the forensic lab.
Yes, any report of the forensic? What was the original crime? Unlawful activities. Mobile is a active part in unlawful activities. Yes. Hmm. 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 Does the forensic laboratory even know that this court is in session of this matter? to the FSL. Which FSL does it go to? Is it done here in Guwahati or in Kailipara itself? Yes, yes. No, we just need to know if the FSL says that there are vital. That is what we want to know, that what does the forensic laboratory report say? From September, they have not done it. No, no, no. You see, in the first order, you are required to submit a report as to why the mobile custody of the mobile phones are required. Where is that report? Can you give us that report? Then we will see whether it, because this FSL report has been called for because it may not be possible to release the mobile phone, not because he wants it. Saying what? We are not on that. The first order of this court says that investigating officer is directed to submit a report as to whether the requirement of retention of the mobile phone is still there for the purposes of investigation. Huh.
Several communication was made to the office of the customer, their organization, and in this phone.
Okay. Okay. Heard Miss Sen, so you are your name?
MN Konyak Lodge.
Learned Council appearing for the petitioner also heard Mr. K.K. Parashar, Learned Additional Public Prosecutor for the State of Assam, by the order dated 14/11/2025. This court had recorded that has recorded the report of the investigating officer that the seized mobile phones are lying with the FSL Kahilipara. And it has been informed by the FSL Kahilipara that the report is not yet ready, full stop. The matter was directed to be listed again today. Full stop. Today, Mr. K.K. Parashar has submitted that by the report of the IO, the IO has reported that a communication had been made to the FSL laboratory on 5/12/2025, comma, response to which is still awaited. Full stop. List this matter again. When? On 26/11 and 5/12, huh? When do you want it now? 8th of January, 2026. Full stop. The IO shall communicate with the forensic laboratory along with a copy of this order with a request to expedite the process so that the matter can be taken up for adjudication. Full stop. Copy of this order be provided to Mr. K.K. Parashar for his necessary communication. We'll have it on the 8th. Yes. Yes, sir.
Lordship, my lord. My lord, here, my lord, the license arm was, my lord, seized by the police.
Hmm.
Lordship, that seizure memo is at page, Lordship,
Why was it seized, sir?
my lord, in fact, in the FIR, seizure menu is a page 28, my lord.
Huh?
License, the pistol, along with 10 numbers of ammunition. My lord, in the FIR, there is no mention about using the pistol, my lord. And the page 26 is the FIR. Here, my lord, some persons, they were unauthorized, my lord, taking some cow from the local areas.
Hmm,
And
okay.
then some persons, my lord, stopped them. And the FIR lost to the effect, page 26, my lord, that those persons, in fact, demanded some money to the, my lord, cow lifters.
Hmm.
And initially, there was no mention about section 25. However,
Hmm.
25(1)(a) was added later on. My lord, in the affair, there is no statement allegation as to use of any arms.
Hmm.
Now, my lord, the petitioner, his license, my lord, I have given the original copy also. Is at page, starts from page 16, type copy. Lordship, in the original copy, page 20. Mukumuni Bora. Now, UIN number, page 21, UIN number is very important, my lord. To
Ah.
ascertain what arms was authorized to use by the license, that can be ascertained by looking into the UIN number. And this police can do this. And without ascertaining that, my lord, the learned court below, while I file a petition for Zimma, my lord, the learned court below say by order, page 34, 23/6/2025.
Yes, yes.
At page 35, my lord.
Ah, we have. It. Yes.
From perusal of the seer, it is evident that the petitioner have misused the arms in commission of extortion. This is why the seize by the IO may elaborately reveal the FIR and other connected documents.
Hmm.
Now, my lord, so far to ascertain that, my lord, that the CD was called for. Now, whether this was at all used and shown to the, my lord, informants. Now,
can copy of PCR was called.
Ah.
Now, it's not such then CBSC because of this, most sent from our office. Otherwise, for calling for a city, because sent from our office, is not there. And because it's not such today.
And moreover, my lord, that while approaching the, my lord, learned this is station just page 40, para 8, my lord.
You tell us, Mr. Parashar, we want two things. One, there was some 164 statement where the person has said that yes, the gun was used to threaten us. And there is another statement here that you are moving for cancellation of the bail, cancellation of the license.
License, yes,
There is, if you find,
yes.
Where did we read it? Page 39,
Right.
para 5. No, para 5, you say that there is a prayer for cancellation of the arms license. If the arms license is cancelled, there is no question of giving it to him on Zimma now. Arms license cannot be cancelled without him appearing before the issuing authority.
Yes, and section 7.
Is it not? Now, since the IO has made a statement on 882025 on the next date of listing, both the copy of the CD and the report of the IO as to the status of that cancellation petition, how has he followed it up? He cannot make an application and forget about it if he's serious about it. Yes, heard Mr. B.K. Das, Council appearing for the petitioner, also heard Mr. K.K. Parashar. learned counsel appearing for, learned APP for the state, full stop. By the order dated 11/11/2025, this court had called for, where did you say it was the PCR? Huh? What did you say it was the mistake in the early order? The confusion?
Case diary was.
Of the criminal revision before the sessions court.
Yes, yes.
A, just a minute. You take it down like this. Mr. KK Parashar has submitted that there is, and there was a little miscommunication with the office where his office had understood that the trial court records are required to be called for, but it appears now that the case has not yet been charge sheeted, full stop. The order dated 11/11/2025 of this court reflects that the records of criminal revision number 28 within bracket 3/2025 were called for from the court of the learned session judge Dibrugarh, as well, that is also not? As well as the case diary in connection with Duliajan PS case number 317 of 2023B call for, full stop. List this matter again on 9th of December, 9th of January 2026, awaiting the records of criminal revision number 28/3/2025 as well as the case diary in connection with Duliajan PS case number 317 of 2023, full stop. It appears from the order passed in the criminal revision number 28 within bracket 3 of 2025 that the IO at that time had made a statement that an application has been moved. That a prayer has been made for cancellation of the arms license of the accused before the district commissioner Dibrugarh, full stop. On the next date, the learned APP shall also have instructions as to the fate of the application made for cancellation of the arms license.
Earlier occasion, LCR was called for, my. Earlier occasion, LCR was called for.
The TCR was called for. Have we received it? Received. You are appearing for number 2, yes? By when? By when? Charge sheeted case, fine. Mr. So-and-so, your name, sir? AK Ahmed appearing for the, has entered appearance for the respondent number 2 and prays for 4 weeks time to file their objections, full stop. Ms. So-and-so learned counsel appearing for the petitioner has prayed for, has shown, I said 4 weeks. Ms. So-and-so appears for the petitioner, full stop. List this matter after 4 weeks on a date to be fixed by the registry, by which time the respondent number 2 may file their objections.
Item 25.
Yes, sir.
May I please, your lordships? In this case, my lord, the both two numbers of petitioners, my lord, originally arrested on, my lord, 30/7/2024, my lord, 30th of July, my lord. And thereafter, in that case, in Tamulpur PS case number 1.
Have we received the updated CD? Updated case diary? Has it come? Oh, yes.
My lord, originally arrested on in another case, my lord, that is Tamulpur PS case number, my lord.
Hmm.
And in the present case, my lord, they were shown a statement.
Hmm.
They've been shown. That is. Lord,
Hmm.
in Tamulpur PS case number, my lord, they were granted bail, my lord,
Huh.
in the year of 2024, my lord.
Hmm.
But in the present case, they were shown arrested on, my lord, shown arrested on, my lord, 6/8/2024, my lord. My lord, it will be better, my lord, to have a look at page, my lord, 12, page FIR of my petition.
This was default bill.
My lord?
That was a case of default bill.
Yes, yes, my lord.
Hmm.
That was the original case, my lord. And in that case, my lord, in this case, my lord, the petitioner were arrested on, shown arrested, my lord. Page 12, my lord, FIR, my lord, page 12. Page 12, my lord, relevant portion, my lord, page 15. Page 15, my lord.
Hmm. Yes.
My lord, may I read, my lord? Yes, sir. With due respect and humble submission, I beg to state that yesterday at around 12 AM, I proceed for night patrolling. During night patrolling at around 2:30 AM, a scooty bearing registration number so-and-so was suspected and followed. As the driver saw the police vehicle, he turned off the lights but continued moving. Due to the road condition and the weather condition of the vehicle of the scooty disappeared in a moment. After approximately 4 to 500 meters near Gormo High School on Hardatta Birdatta Road, the scooty was found with 3 plastic bags suspected to contain
We've
ganja on
seen
it.
that. Yes, we've seen that.
Yes, my lord, the present petitioners, my lord,
Hmm.
neither the, my lord, owner nor the rider of the scooty, my lord,
Hmm.
and another vehicle, my lord, that was also not belonging to the present petitioners, my lord. And nothing has been recovered from their possession, my lord. Nothing has been recovered.
Could not be you were behind bars on that day.
My lord,
You were behind the bars on that day.
my
Or
lord,
no?
yes, yes,
You were outside.
no, my lord.
You were
We are-
outside. This FIR is lodged on 3/6/24.
Yes, my lord.
You were in custody in the other case from 37/24.
But my lord,
Hmm.
my lord, they were relying on, my lord, only one document, my lord. That is at page, my lord, page 24. The prosecution side, my lord, relying on one document, that is page 24. Kindly have a look, my lord. Page 24, my lord.
এখন দিবচোন।
My lord, no, my lord, page, sorry, my lord, page 20, my lord. Page 20.
Electoral voter card and fake agreement.
Page 20, my lord.
Huh.
The alleged incident, my lord, took place on, my lord, 3/6/2024, my lord. And, my lord, from the seizure list, my lord, it appears that, my lord, description of the seizure, my lord. Description of the seizure, that is clause 2, my lord.
Hmm.
One duplicate,
Yes, yes.
yes, one duplicate car leasing agreement, self-declaration form in between owner of Goizi Tours and Travels, Sri Mukul Singh, 49 years, son of so-and-so, so-and-so, and Sri Kumud Boro, that is the petitioner, my lord, son of Khogen Boro of village, Balahati, PS, Goreshwar district, Tamulpur, Assam, for one Baleno vehicle white registration number A01EP 8557. That is, my lord, pickup date. Kindly see, my lord. Pickup date is, my lord, 2/5/24, my lord. Pickup date 2/5/24, my lord. And, my lord, drop date, my lord. That vehicle was returned, my lord, on 4/5/24 at around 4:20 PM for 2 days. For 2 days, my lord. And, my lord, the alleged incident, my lord, took place on, my lord. LS incident, kindly have a look at page 15, my lord. That is took place on, my lord,
36.
3/6/2024, my lord.
36, huh?
Yes. That is, my lord, prior to that incident, my lord.
Hmm.
And vehicle was, my lord,
What was your elector card doing there? Original elector card?
my lord.
Serial number 1? You have read serial number 2. What is serial number 1?
Serial number 1, original elector photo identity card,
Of?
right? In the name of Kumud Borough, my lord. I have given, my lord, at the time of, my lord, leasing, my lord.
So when you gave the car, when you gave the car back, you did
Yes,
not
my
take the photo, electoral voter back. You let it remain in the car.
My lord, that was, my lord, already, my lord, returned, my lord. That is
What was
specifically
returned?
returned, my lord.
What was returned?
My lord,
The
car
car.
was returned, yes, my lord.
So when you returned the car, you
Yes,
did
ma'am.
not take back the electoral card, electoral voter card. You let it remain inside the car.
In the name of Kumud Borough, this document has been seized from the petitioner, my lord.
No.
From the petitioner, my lord. And thereafter, my lord, already, my lord, 482 days, my lord, they are behind the bar, my lord, and almost, my lord.
It's the stage of the trial. How many?
My lord, 9.
9 witnesses examined
Yes.
out of 13. 125 years. Huh.
I have annexed, my lord, 7 numbers of, yes, I have annexed, my lord. Chief and pros, my lord, kindly see.
He has not been? Huh.
Owner of the vehicle, and he said that, yes, in the car on that. Where on this vehicle, I contacted the vehicle bus, I don't know the vehicle.
But that was,
Yes, we are coming here.
but
On, after that, we are coming into. I, this, that file is, student requirement, and first, search number, over the data, as of the, after PCR, out of 49 days are already done. So, this was.
How many days he has spent now behind bars?
482 days as on today,
What
my
is
lord.
the longest term in preventive detention? NDPS? Longest term? Preventive? 1 year? Maximum. He has spent 4 times, three times. Mukul Singh will come. Why keep him behind bars now? If he is involved, he is convicted, is he not? In anticipation of a conviction, we can anticipate an acquittal also. Just tell us why they continued after 480 days, why the continuation is necessary. That is what we are trying to find out. Are we required to keep him behind bars at this stage also? What is the quantity? Commercial quantity. And the second case, this is the second case. Shown arrest, involvement in a second case. That is what.
My lord, I have annexed, my lord, all the PWs, my lord, what the PW says, my lord. Nothing, my lord. You kindly see at page.
What is the next date fixed? In the trial?
Next date, my lord, I could not obtain, my lord. I have annexed the 7 numbers of PWs, my lord. Their statements and my lord, cross-examination, my lord. From test 46, my lord. There was nothing, my lord, stated regarding the petitioners, my lord. No any whisper, my lord. My lord, kindly have a look at page, my lord, 14, my lord. 46, my lord.
Huh? Hmm.
1, 2,
Hmm.
3, my lord,
I think for the rest of the trial, but in this case, his only his voter ID has been found in the car. And the ranked agreement was for a prior period, not for that period. Had it been for those days also, we would have not considered it, but it was for a period prior to that. The incident is of June. 31/8. Arrested on 3/6. 25/1. 4/1/25. Rest of the trial, I think we can. Hmm. Total number of witnesses to be examined is
already 9,
13, four remaining.
already 7 I have annexed, my lord.
Hmm?
7 numbers of witnesses I have annexed with my petition, my lord.
Hmm.
My lord, in 7 numbers of witnesses, my lord, there is nothing, my lord.
Commercial quantity. You finish the trial. Commercial quantity, two occasions, I don't think.
2 days,
Huh?
my lord. In my main case, my lord, he was granted bail, my lord.
No, this
In-
this is the second case. And it's a huge commercial
Incident, my
quantity,
lord.
26 kilos.
My lord, only one document, my lord, they are relying, my lord, that is the, my lord, that car leasing agreement, my lord.
Hmm.
That is self
And your original voter's ID.
My,
You are letting your voter's ID be here and there with Mr. Mukul Singh,
but my
whose
lord,
in
that,
whose vehicle all these things are found.
my lord, that car has been, my lord, returned, my lord. On, that is, my lord, specifically written in the, my lord.
No, that is the agreement which says that on that day the car ought to have been returned. Had you returned the car, you would have taken back the voter ID. Why would you leave your voter ID there?
If, my lord, I was the custodian at the time of, my lord, incident, my lord,
Mhm.
then, my lord, Mukul Singh might have told that, my lord.
Let the trial be completed. Not at this stage. Almost over. Nine witnesses gone. 4 more to go.
But, my lord, in 9 witnesses, my lord, there is nothing, my lord.
Get an acquittal.
My
That will,
lord,
that will,
then
that
it
will be
will
a case
take
for
much more
acquittal,
time,
not for
my lord.
next.
My
Next
lord,
time.
at least, my lord, if possible,
You want the
time
order?
frame, time frame.
You
maybe,
want us to dictate the order now? Okay.
my lord, time frame, maybe, my lord.
Heard Miss, huh?
Time frame, my lord, at least for completion of
We will
the.
consider. Yes, heard Mr. S. Ahmed, learned counsel appearing for the petitioner. Also heard Mr. So-and-so, learned counsel. Learned additional public prosecutor for the state of Assam. By the last order, this court had required the scanned copies of the proceedings of the trial court conducted after 26/8/2025 and to place it along with the records. Full stop. This is an bail application under Section 483 of the BNSS in connection with special NDPS case number 15 of 2024 under Section 20 within bracket B within bracket Roman 2 small outside bracket capital C of NDPS Act arising out of Goreswar PS case number 32 of 2024 pending before the learned special judge Baksa. Full stop. The petitioners were shown arrested in this case on 6/8/2025. Full stop. The learned counsel for the petitioner has submitted that the petitioners were that the petitioner was in judicial custody since 37/2024 in connection with Tamulpur PS case number 170 170/2024, full stop, during his custody itself, comma, the petitioner was shown arrested in the present case, that is Tamulpur PS case number. This one is what?
That is Goreshwar PS.
Gureshwar PS case number 32/2024 on 3/6/2024. Huh? Just a minute. He was shown arrested in connection with Tamulpur PS case number, so and so, Gureshwar PS case number 32/2024. On, when were you shown arrested?
6/8/2020.
On 6/8/2024, full stop. The learned counsel for the petitioner has submitted that by an order dated 22/10/2024, the special judge, comma, Baksa, comma, Mushalpur, had allowed the bail petition of the petitioner in connection with Tamulpur PS case number 178/2024. Full stop. However, due to pendency of the special pendency of special NDPS case number 15/2024, comma, the petitioner was not released on bail, and he continues to suffer incarceration from 37/2024 itself. Full stop. The learned counsel for the petitioner has submitted that keeping in view the long detention of the petitioner, and also in view of the fact that none of the prosecution witnesses examined till now have made any statements against the petitioner in special NDPS case number 15/2024, comma, the petitioner may be the prayer for bail by the petitioner may be considered by this court. Full stop. The learned APP has submitted that 9 out of 13 PWs have already been examined and only 4 remain to be examined. Full stop. The investigation in this present case was completed within a period of 2 months from the date of the lodging of the FIR, and the charges were framed on 4/1/2025, and already 9 witnesses have been examined. Full stop. It is submitted that it is submitted by the learned APP that one of the most vital witnesses, that is the owner of the vehicle from which the commercial quantity of, what was it? What was recovered? Ganja? Commercial quantity of ganja, comma, set at 42.750 kg without packing had been recovered, is yet to be examined, and therefore releasing the petitioner at this stage may hamper the may hamper the prosecution. Full stop. We have considered the submissions made by the learned counsel for the parties, and we have also gone through the TCR placed before us. In view of the stage of prosecution, and also the fact that vital witnesses are yet to be examined, and also in view of the fact that commercial quantity of ganja is involved, and that this is not the only case in which the petitioner appears to be involved, comma, this court does not no, this court is not inclined to grant the privilege of bail to the petitioner at this stage. Full stop. The bail petition is accordingly rejected. Full stop. The petitioner would be at liberty. Do we give that liberty after completion of the prosecution witness, or can he come back?
After examination, my lord, that is the honor of the term, my lord.
The petitioner would be at liberty to approach this court, to apply for bail after the evidence of the prosecution witnesses are completed. Once they complete it, then you come back, we'll see.
Obligement.
Huh? Nalage, to
That
return
is
it.
Tamulpur PS case number, my lord, 178 oblique 24, my lord.
Huh?
Tamulpur PS case number 1, my lord,
Two cases, one is Gureshwar 32, Tamulpur 178.
178 with 24, my lord. Obligement.
Side over, huh?
Obligement.
Item 26.
Lordship, 120 days in jail custody, Lordship. Here, Lordship, POXO 6 is there, Lordship. As per Lordship, section 35 of the POXO Act, the evidence of the victim has to be examined within 30 days.
Mm.
Then Lordship, 364 of the BNS says, Lordship, the trial has to be completed within 2 months from the filing of the charge sheet, Lordship. These are two violations, Lordship. They have not completed the trial within 2 months, and the statement of the victim is not recorded. So far, my instruction. That is the ground for,
This, the statement of the victim not recorded till now.
because Lordship, it's a charge sheet.
Huh? Trial court record to আইছে নাকি এটা? Hmm? It is not shown in the cause list. Yes.
So, Lordship, there is a direction from the Supreme Court, Lordship, in the Anna woman Valada versus State of Maharashtra, Lordship. Every bail application has to be disposed of within 2 months, Lordship. That was not, this case is pending from the month of September, Lordship.
But the service report in respondent number
Service
120,
re- yes,
respondent
Lordship,
number
that
2
was-
has
that-
been.
That they have to confirm, Lordship. It was, service was taken, Lordship, long ago, Lordship. The public prosecutor is
Yes, sir, when-
representing the case, Lordship.
Huh?
Public prosecutor is representing the case, Lordship,
Yes.
prosecution side, Lordship.
Yes.
Now only they are participant, Lordship. Now this detention, Lordship, how long this petitioner will be kept in jail, Lordship?
You are reminding us of ideal situations, what they call ideal situations, huh? 16 years.
It's an extramarital affairs, Lordship, the brother-in-law having relation with this, that. Last. because
Charge sheet has been submitted.
Yes, Lordship, charge sheets have been.
Ah.
It's for evidence.
Yes. Yes, by the earlier orders, comma, the Bullet PP was required to take instructions. Regarding the service of notice on the respondent number 2, comma, today he pays for some more time to have his instructions, full stop. The case diary, have you received the case diary? No. No, it was done only,
Along with the case diary, Lordship, that is.
when was when was it charge sheeted? 27/9/25. It was during the pendency of this case. Call for the scanned copy of the trial court reports in connection with, education detail to the Diba, huh? Connection with so and so. List this matter again on, yes, when will you have the instructions? Respondent number 2. 15th of December 2025. Stop. Yes, we will have his instructions. Let us see.
Okay.
Someone.
27.
May I please? Lordship,
Yes.
kindly pass over the matter for the time being.
Pass. Password. I'm sorry. Yes.
PCR was called for.
Hmm. Perhaps the case has already been charge sheeted, yes. Whether charge sheeted? What do you want to do, madam? Charge sheeted?
90 days behind bar as of,
Ah,
keep 90 days behind bar as of today.
in a POXO case? We'll keep the days in mind, could we? It has been charge sheeted, what do you want to do?
PCR. Actually, it is a case of love affair, actually, Lordship.
Hmm? What is the age of the girl?
16 years. Accused is 23 years.
Hmm? The law says you cannot love before 18 years. Prohibits. What to do? Went for her upper primary school? Why is a 16-year-old girl going to upper primary school? Huh? শিক্ষা গ্রহণ কৰিবলৈ যাওঁতে। Yes, the SMS version also says so. 16-year-old girl going to upper primary school. Where is the girl now with the parents?
Yes, Lordship.
And where is the birth certificate? Nothing. See the distress the family is put to. The father has to take custody of the victim by executing a bond of 5,000 rupees. It is his own daughter. Huh? Heard Mr. So-and-so learned counsel appearing for the petition also heard Mr. So-and-so learned APP, comma, it has been submitted that and it is noted in the order dated 24/11/2025 that the prosecution was required to take instructions regarding service of notaries through the concerned PSCS. You're appearing? Mr. So-and-so appears. Your name? S. Hussain, counsel appears for respondent number 2, full stop. The scanned copy of the case diary along with the charge sheet had been called for by the order dated 24/11/2025, full stop. The office note do not reflect that. Oh, today is what date? The office note dated 6/12/2025 reflect that the scanned copy of the TCR has not been received, full stop. Issue reminder for TCR, list on. January 9, we are burdening up, sir. Mr. Courtmaster, are we burdening January 9? Huh? Fine. List on January 9. What is your take in the matter? You are opposing the bail or you want him on bail? You have no objection. The law may not allow, the father allows. What do you do? Yes.
Obliged, Lordship.
Hmm?
May I please, Your Lordship? Lordship, 483 application, Lordship, 195 days behind bars. Lordship.
Respondent number 2.
That matter, Lordship.
Respondent number 2, you are the father. What is your take? Huh?
Yes, I am.
No, you are the father. You had lost the FIR. saying that my daughter has been done this and done that and done this. And now he's behind bars. And now the father says that do whatever you like. You want him to be released on bail or you want him to remain under custody is what we are asking you. Huh? What did the father say? He wants the person behind bars or जो होता है होने दो. Huh? If that is the attitude, then why he would have lost this FIR? Do you really have instructions? Have you asked the father? Now, the victim has attained majority now. As and when they will also now agreement for child marriage also. Yes, yes, tell us.
My case, Lordship, there's upon two grounds, Lordship.
Huh?
First thing is that, Lordship, it is still in the stage of framing of charges, Lordship.
Hmm.
8 months, Lordship, there's a vacancy of special judge in Kolkata,
Huh.
Lordship. So it is still in that stage, Lordship, for 8 months. Second thing, Lordship, second thing is that, Lordship, we have annexure 5, page 24, that is notice under section 47, Lordship.
Ah,
They have given, Lordship, in 47, Lordship, page 24, they've given reasons of arrest, Lordship, but no grounds of arrest have been given to him. At the same time, Lordship, in the forwarding report, which is on page 16, they have given both grounds and reasons there. But in the section 47,
notice.
yes,
Where is the notice?
Lordship, kindly firstly come to page number 16, Lordship.
1-6.
1-6, Lordship, that is
Ah.
the forwarding report.
Hmm.
Here, Lordship, both grounds and reasons of arrest have been given. This is the forwarding report.
Hmm.
Thereafter, Lordship, page number 24,
20?
24, Lordship, annexure 5.
Hmm.
Here only, Lordship, detailed grounds of arrest, only reasons of arrest have been given. That is number 1 and number 2.
Where?
That is on
Detailed
last
ground
slide.
of arrest.
Yes, detailed grounds of arrest. These are reasons of arrest, Lordship.
Hmm. Yes, sir. Hmm?
On detail, but further down regarding the purpose of having notice of Sanga 47, he has to engage a counsel why he was arrested. That's sufficient. It was clear notice. The accused person directly involved in the case, he has confessed that he had illicit sex.
Just a minute, Mr. Goswami. It is here. January to could come from. But January maha niki? Ne December. Huh? Huh? এই রঙাটো মানে মই ফিক্স কৰি থৈছো মানে চিভিল কেছ যে 8টা মোৰ চিভিল বেঞ্চে নাই আপুনি চিভিল কেছ 8টাটো কেনেকৈ ফিক্স দেখাইছে আজি কাৰণে আজি কি তাৰিখ 10 তাৰিখে কেইটা বেলেগত দিব কাৰণ এইটো মই ফিক্স কৰা বস্তুখিনি Okay, understood. Okay. Yes.
The accused person directly involved in the case, he has confessed that he had illicit and sexual relationship with minor girl.
Yes.
That the person is involved in this case and sufficient evidence. His witnesses have been found against him.
So, এখন চাওঁচোন ট্ৰায়েল court TCR আহিছে নেকি TCR can you just tell us what all has been seized? What has been seized? Just tell us from there. And that is why I said, just tell us what has been seized. And it has not been charge sheeted, it has been charge sheeted.
Lordship, charge
It
sheet,
has been charge sheeted.
but it is.
Have a,
listed
have
as
a, have a
criminal.
rethink about this, Mr. Goswami, what we are saying. We do not approve of this kind of a relationship, but a 20-year-old boy behind the bars because he did something to one lady, the environment he will be inside. A drug peddler, maybe some other bigger issues which reflect on the society immediately. Those people in that situation, and a 20-year-old boy who fell in love with a girl and not looking at her age took advantage of the absence of the parents. The continuation of his presence in that situation. Done so. We understand that. Conviction, there is no problem. Conviction, there is no problem. But now, given his age, given the accusation against him, these are times when everybody needs to be careful with the children. Allowing him to be in that situation, how far? So that is why I was asking, what is the seizure, whether the birth certificate has been seized? Original birth certificate is there. 9, 1910, and another 6. 16 years. Okay, we'll come back and see. Thank you. Yes, sir. Tell us. Hmm? He has no objection. So the possibility of the victim being influenced is not being raised by the father of the victim himself. That is the only thing. We'll be creating circumstances where he will have access to more heinous criminals. So in that view, I think we'll put on all the stringent conditions as possible. Yes. Yes, take down. Heard Mr. So-and-so, learned counsel appearing for the petitioner. Also heard Mr. So-and-so, learned APP appearing for the state of Assam, and Mr. M. Alam appearing for the respondent number 2, informant, who is the father of the victim. Full stop. This application for bail has been preferred by the applicant, who was arrested in connection with
Pokrajhar PS case number 129/2025.
Pokrajhar. You can take that from the front page. So and so he was arrested on
28/5/2025.
On 28/5/2025, full stop. The perusal of the FIR records that Where is that FIR? That
FIR is on.
the father of the minor victim, of the victim had lodged in, had stated that the accused had taken advantage of the absence of parents in the house and had physical relationship with the victim, full stop. Accordingly, the aforesaid police case had been registered and the accused was arrested, full stop. The learned counsel appearing for the petitioner has submitted that the relationship established, comma, if any, was with the consent of the victim, comma, as they were in a love affair. Or was it forced?
It was a love affair, Lord.
It was a love affair.
There was on calls.
The learned counsel has submitted that keeping in view the age of the petitioner, who is about 20 years, comma, and no, he may be granted, and he may be granted the privilege of bail since he has completed more than
195 days.
195 days in custody, full stop. The learned counsel appearing for the respondent number 2, comma, the informant has submitted that he does not apprehend any influence or coercion by the petitioner. Full stop. The learned APP has submitted that the consent or other relationship with the minor in this case would be of no consequence since the provisions of POCSO Act are involved. Full stop. He accordingly prays that the petition may be rejected, full stop. We have gone through the contents and also the records called for. Stop. The case has been charge sheeted. Full stop. Therefore, there is therefore there is little or no apprehension of tampering with the evidence collected by the prosecution, full stop. The respondent number 2 informant has not raised any apprehension regarding influencing of the prosecution witnesses, full stop. In view of the above, this court is of the opinion that the petitioner, comma, aged about 20 years, is entitled to the privilege of bail at this stage. Full stop. Accordingly, the petitioner be enlarged on bail on furnishing a bail bond of rupees 20,000 with 2 sureties of the like amount, subject to the satisfaction of the learned trial court. Full stop. The following conditions shall also be applicable on the petitioner, full stop. And put down those conditions, whatever conditions. Bail application disposed of.
Deeply of, Lord. Deeply of.
I'm being item 27.
Yes, sir. What is this? What is this order of 22-10-2025? Is it the same case?
Interim bail was granted.
Huh?
Interim bail was granted on 22nd October. Because the petitioner has been in the hospital
Hmm.
before and after also. And actually, the statement of the accused, co-accused, on the co-accused. stated
So
that
now you have undergone the surgery. Have you undergone the surgery?
I have gone to the hospital and the doctor has given some medicine and for further surgery, prescribed.
Huh?
Further
Surgery.
surgery, yes.
Hmm.
Because some medicines are prescribed fast because severe bleeding is going on in Guwahati Medical College Hospital. So that is suggested that you should take the first medicine.
Oh, bleeding piles. Can it be done this way, Mr. PP? What we propose to do is we make the bail absolute for the time being, allowing him to undergo the surgery. On the completion of the surgery, he will report back to the trial court.
Yes.
And the trial court shall consider whether he would remain on bail after the surgery or not.
Yes.
If anything is found that that bail should be revoked, trial court would revoke it. Because every time after every 1 or 2 months, it will come up, this complication in surgery, that complication in surgery, interim, it will keep on going on. So if we dispose this off, allowing him to undergo the surgery as per a doctor's advice on the same terms and conditions which was imposed. And then immediately after the surgery, he has to report back within a period of 7 days from the date of the surgery. Whereupon the trial court would then further considering whether the bail can be extended or it needs to be recalled.
And further, my lord, that in paragraph 10 of the last order, they said that the seized mobile forensic analysis was sent for, but he has no mobile. The petitioner is a cultivator. He has no mobile. Now that forensic.
Where does
Can listen by the trial court. Whether
No.
that mobile belongs to me. Because this cultivator has been, my lord, under instigations of this.
Mr. Saikia,
Hello,
we have expressed our mind that we are granting the bail
my lord.
subject to certain conditions. Now, should we go into whether the mobile is his or not?
The trial court will see.
Huh?
Trial court will see, trial court.
Huh? So I don't need to adjudicate that. Heard Mr. R.C. Saikia, Learned Counsel, Learned Senior Counsel appearing for the petitioner assisted by M. Sharma. Also heard Mr. So-and-so Learned APP for the state. By the order dated 22-10-2025. Have you received the updated the CD? Huh? Anything? Huh? No, anything after 22-10-2025, any material which you have got after 22-10-2025. 16-10. So till 22-10, whatever was available, this court had, the court had granted the bail. So we just continue that since nothing more has been, yes. PP full stop, the learned APP submits that the case diary is available. However, nothing further against the petitioner is reflected on the case diary as of today. Up to 16-10 full stop. Thus, the situation remains as it was on 22-10-2025 full stop. By the order dated 22-10-2025, this court had gone through the case diary and the submissions made and had also referred to the different judgments and had deemed it fit to grant interim bail to the accused for a period of 6 weeks to enable him to undergo the surgery indicated in the medical certificate produced by the petitioner, full stop. The petitioner was required, Mr. R.C. Sekia, learned counsel, senior counsel appearing for the petitioner has submitted that by the prescription dated 9/12/2000, today's prescription.
It is prescription, but admitted on 5/12/25. On first page, madam, first page.
That has referred to the advice slip issued by the Guwahati Medical College and Hospital, which reflects that the patient has been had visited the said hospital on 5/12/2025.
Madam.
Is he admitted?
And
No.
he is going to be admitted. This medicine.
I had visited the hospital on 5/12/2025 and has been prescribed certain medicine even on 9/12/2025 to prepare him for the surgery. Full stop.
10 days rest is given. 10 days rest, bed rest for 10 days.
Huh.
In the program portion, my lord, last.
The petitioner has been recommended to stay, advised to stay under rest for 10 days. Full stop.
Before surgery.
Huh?
Before surgery.
Before the surgery, full stop. In view of the projections made, this court deems it fit to make the interim bail granted to the petitioner on 22/10/2025 absolute to the extent that the same shall remain in force till the petitioner undergoes the surgical procedure recommended by the medical authorities. Full stop. The petitioner shall, within 7 days after the surgical procedure, appear before the learned trial court, on which day the learned trial court shall consider whether the petitioner can be allowed to remain on the bail granted or the same is required to be revoked. Full stop. It is further submitted that in case the petitioner does not require to undergo surgery after the treatment now being taken, he shall in any case report before the learned trial court on or before the 14th of February 2026, on which date the learned trial court shall consider the requirement of continuance or otherwise of the bail being granted.
Right.
Bail application
Okay.
disposed of.
Item 9.
Yes, we are told that since the bench is not available, therefore huh? CD has to come.
224 days.
So
And in case of small quantity, Your Lordship.
where do we find that?
No, it's according to police, it's a 22C. However, Your Lordship comes to the page number 24, Your Lordship. It's the
Page number
23.
23.
In 23, the order, interim order passed in respect of the main petitioner, the main accused petitioners. They were allowed to interim protection, Your Lordship, since it was,
Page number 23.
there's a 24.
Huh.
These two petitioners are the main accused. They have been protected, Your Lordship, since it's a case of small quantity. The petitioner number 1 in this case,
You are who?
I was arrested on 29/4. I'm not in there. I'm not on interim. I was arrested on 29/4, Your Lordship. My forwarding would find, Your Lordship, at page 17. That's the forwarding.
What is the charge against you? 27A, no.
27, there is no material.
No, where is your,
My, yes. The charges are 21A, 22C.
where do I find it?
The FIR, Your Lordship.
Your name?
PJ Das, Lordship.
Abu Ahmed Taj, huh?
Oh, yes.
Abu Ahmed Taj, okay.
Only 25 and 27 against me.
And 29.
There is no-
27, nothing.
No, no, there is no material. Page number 26, Lordship. The co-accused was released on bail. Same FIR, Lordship.
Yes, sir, this is piece, Mr. Parashar. Page 17 shows him. Abu Muhammad Taj
Yes,
Hussain,
number one.
number 1. Is it?
Yes.
Then when we went through this entire thing, I do not find anything recovered from him, huh? Huh?
Yes.
Hmm.
No, 1.30 gram is the actual quantity.
When
and
were you arrested?
29/4, Your Lordship.
And this is dated when? You are not Minu Ahmed.
No, no, yes. I am Abu Muhammad Taj alias Minu Ahmed.
Hmm. Now, where does this man come in? At what part?
In the petition, Your Lordship would find
From page 17 to page 24, where do you come in? Where is your name?
it's
Except at page 22.
Lordship, I was not directly involved.
What did you do?
Yes, the main accused were involved.
What did you do?
Yes, I was there. I was a driver, Your Lordship. I
Where?
taken the. It is not in the FIR, Lordship.
19, yes.
Shankar and his wife are running a huge business of NDPS agents, which have a huge organized network for this purpose. They say that one BPLE and also Minu Ahmed, alias Abu Muhammad Taj Hussain,
Ah.
are six members of the gang.
This Shankar Sekia was granted interim, and this Biki Ali was also released on bail, Your Lordship. Both the orders I have annexed. This Biki Ali, that's a co-accused, was released on bail, Your Lordship, and Shankar Sekia and his wife also granted interim protection. Your Lordship.
Sometime with partisan. Being the somewhat from by some tablets and all the medicines. And even after our objection, we get it.
We produced medical certificates, Your Lordship, by which I was prescribed to have some tablets. These are the tablets which are available in the seizure items, along with the.
You are already charge sheeted in
no.
Morioni PS case number 205 of 2016. What
It's
is
an
that?
earlier case.
Second case. That you should have told us long before. We would have not
No, I'm not on that case.
Why?
I do not have any, otherwise I had no idea.
You were on bail in that case after charge sheet. Hmm?
That information I was not carried to me.
What to do?
Because of the ED was here, ED they are taking back last week. So you have filed it, okay?
Lordship may close it today, Lordship. Otherwise, it's.
Then we have to allow it. Yes. The heard learned counsel for the petitioner. Also heard the learned, also heard Mr. K. Parashar at APP. Full stop. This application for bail has been preferred in connection with Moriani PS case number 51 of 2025. Under section so and so of the NDPS Act. Full stop. The petitioner is in custody since 29/4/2025. Full stop. The learned counsel for the petitioner has drawn attention of this court to the FIR dated 16/4/2025, by which some amount of contraband substance had been recovered from the premises of one Shankar Saikia. Full stop. Thereafter, it appears that thereafter thereafter the petitioner herein was arrested on 29/4/2025, and in the forwarding report, the IO has stated that the petitioner was seen by the public to be escaping with one Shankar when some other persons were seen to be consuming contraband items. Full stop. The learned counsel for the petitioner has submitted that by orders dated 25/6/2025, the said Shankar Jyoti Saikia, and also by the order dated 13/8/2025, the person who was seen along with the petitioner when they were escaping have been granted the privilege of bail. Full stop. He thus prays that the petitioner, comma, from whom no contraband has been seized and who has only been arrested on basis of suspicion may be allowed the privilege of bail. Full stop. Learned APP has objected the prayers for bail. Full stop. He has, however, submitted that as per instructions, comma, the charge sheet has not been submitted till now. Full stop. We have considered the learned the submissions made by the learned counsel for the parties, and we have also gone through the reports available. Full stop. In the circumstances involved, comma, we deem it fit to grant bail to the petitioner in connection with the aforesaid case. Full stop. The petitioner shall be released on bail on executing a bond of, furnishing a bond of rupees 20,000 with 2 sureties of the like amount, subject to the satisfaction of the trial court and subject to the following conditions. Or subject satisfaction of the arresting authority, How it will be the arresting authority? He has been forwarded in judicial custody, eh? Yes. Good. Subject to the following conditions, huh?
Diploma.
1, 2, 3, 4.
Item 32.
Hmm.
Pending, we have filed it on 11/11, then 14/11, we have moved it, Lordship.
Hmm.
25/11 is the last order, 25/1/11, Lordship. We are behind the bar for last 175 days. It is a case of option order, Lordship. Love affairs, 22-year-old boy, Lordship.
But until and unless the
So,
respondent number 2 does.
sit right on this our shoulder, Lordship, because we have already notice has been given to them. They are
True,
not
but
reporting
unless
back.
and until
They are not
the
reporting back, Lordship. That's it.
until and unless the respondent appears, that
No,
is a
Lordship can appoint an MI class, Lordship,
not out of the blue.
or
Not out of, if
because
they
the
say we have failed,
last date has been fixed for taking instructions, Lordship.
the instruction is received.
So we have issued the notice that that's also on the note sheet, Lordship.
Yes.
And according to our instruction, they have received the notice.
Next week. The learned, Mr. Goswami, learned APP has
Because
submitted
then
that
they will not come, I have to.
he has,
Would have to appoint an MI class, Lordship. That's the
Ah.
problem, Lordship.
he has received instructions that the service is not complete. However, the learned counsel for the petitioner has objected to the same and has stated that as per his instructions, the notice has been received
That is
by the
received.
informant, full stop. Mr. Goswami prays that this matter may be taken up next week for him to have written instructions on the matter.
Or on
Full stop.
last Friday, Lordship.
List this
If
matter
possible,
again on
12, Lordship.
on 15/12, he's
15.
asking for 15/12, 15/12/2026, by which date the learned APP shall ensure
Lordship.
the receipt of written instructions. Yes.
By your lordship will find page 9. The allegation is that some betel nuts were recovered from the godown of the present petitioner, lordship.
Hmm.
And it is suspected that he is a smuggler of those betel nuts.
Betel nut.
That is the allegation, lordship. I am having valid documents, lordship, page 19 onwards. Page 19, your lordship may kindly see that GST registration certificate.
Yes.
Then lordship, page 21, also the PAN card details is there. And page 22, lordship, that GST registration.
You are
certificate
shown arrest.
shown it. That in earlier case, your lordship granted bill that kettles were found from his house.
Ah.
From godown, lordship.
Ah.
Some kettles were found that without asking for documents, they have arrested. Subsequently, I produce all the documents. related-
Why is it that every time you have something huge quantity in your house, you produce the documents, police don't look into it?
That, lordship.
Why does it happen every time, and how do you have so much of material inside your house?
No, not house, lordship. godown.
3,880 kg of
That is the godown.
betel nut.
That is the godown.
How many cows were there?
111.
111. A huge property it must.
Lordship, that godown is there.
And anything and everything which is not supposed to be on the market is
Legal-
inside your
legal
godown.
documents, legally, legal. That he has.
Yes,
purchased from
case
home
diary received. What have you found?
And 34 days.
Huh? Hmm. That time he could not produce any documents. Now he has some documents. What happened to the areca nuts? Confiscated,
Already seized, not confiscated.
seized. So the next application is for Zimma. Yes, he has some receipts and all. And this, he did not have it then on him. He had it in his house. He could not. Huh?
Nobody keeps documents hidden from the police. They procure all, they shows all the documents.
But why none of these documents that you have produced?
They have
There is no weight, no
And in fact,
cone.
otherwise also, in this case, he is shown arrest.
Huh?
In this case, he is shown.
Shown arrest. But recovered from your godown,
That I admit, those are those.
along with the cattle.
No, kettles, for kettles, separate godown is there.
Yes, huh? You are important. Very look. Harry, take down. Heard Mr. So-and-so, learned counsel appearing for the petition, also heard Mr. So-and-so, learned counsel appearing, learned APP. Full stop. The present application has been filed by the petitioner wherein, praying for bail in connection with
In connection with Goroimari PS case number 100 of 2025.
100 of 2025. Registered under section 303 within bracket 2, comma 318 within bracket 4, oblique 112 within bracket 2 of BNS 2023. Full stop, wherein he was shown arrested. Full stop. The allegations in the FIR reveal that a raid was conducted in the godown of the petitioner, who was shown to be involved in cattle smuggling activities. And during the raid, a total number of 97 bags of suspected smuggled areca nut weighing 3,880 kilograms were recovered from the godown. Full stop. During the course of the operation, the family members were asked to produce valid documents or papers related to the possession and transport of the betel nuts. However, no such documents were produced. Full stop. The recovered betel nut was seized and the petitioner was shown arrested in the present case, as he was already in custody with regard to the case relating to the
Palassbari police station.
allegations of cattle smuggling activities. Full stop. The learned counsel for the petitioner has submitted that since the petitioner was already behind bars, comma, he could not at that point of time produce the relevant documents regarding the manner in which he came into possession of the betel nut seized by the police. Full stop. However, such receipts of the betel nut having been brought is now placed before this court along with the bail petition. Full stop. He has therefore pleaded that since the betel nut is accounted for, comma, the same are not smuggled in any manner, and therefore the petitioner may be granted the privilege of bail at this stage. Full stop. The learned APP has objected to the prayer of the petitioner for bail and has submitted that the investigation is still on, and therefore there is an apprehension that the petitioner may hamper or tamper with the investigation. Full stop. We have considered the submissions made at the bar. We have also gone through the contents of the bail petition. Full stop. Case diary has been received. The learned APP has also produced the case diary. Full stop. In the given facts and circumstances, since the petitioner, this court is of the opinion that the petitioner may be granted the privilege of bail so that he may produce all necessary documents before the investigating authority to prove the manner in which the suspected betel nut had come into his possession, full stop. Therefore, this court directs that the petitioner be released on bail in connection with the so-and-so case on furnishing a bail bond of rupees 15,000 with two sureties of the like amount subject to the satisfaction of the
Chief Judicial Magistrate,
Chief
Amingaon,
Judicial
Kamrup.
Magistrate. Amingaon, Kamrup. Also, the bail shall also be subject to the following conditions. Yes. The petitioner shall produce all relevant documents before the investigating officer with regard to the seizure made within a period of 15 days from the date of his release on bail. Yes.
Item 35.
This matter was earlier listed on 5th of this month, my lord. On that day, we have submitted this, the information has already received the
Yes.
lordship.
Received what from the registry? Eh?
One thing, my lord, the case is listed today without updating the office note. That's why maybe fixed next week, my lord, with updated office note.
The last office note in the records of the case is of 3/12/2025. And the matter was thereafter taken up on 5/12/2025, full stop. Okay. Let this matter be listed again on 15th. Huh? 15th of December 2025. Full stop. The learned PP shall retain the copy of the case diary which is stated to have been received. List this matter again on 15th along with updated status. Updated status of the service report. PP to retain the copy of the CD stated to have been received. Yes.
56. An 18-years-old boy, my lord.
Huh?
18-years-old boy.
18 years old boy,
183 days, my lord.
183 days old. The learned APP has submitted that the service report that the service on the respondent number 2 is complete. Full stop. Matter relates to arrest of the petitioner in a case involving provisions of the POCSO Act, full stop. There is no appearance on behalf of the respondent number 2, full stop. In view of the above. Put go lekon kali ekhono late hoisil. Apnar heri. America sir. Please, who can come? Mr. Surajit Das, our Harana Council, is appointed as an amicus curiae to appear on behalf of the respondent number 2. Full stop. Copy of the said, copy of the bill petition be served on the amicus by the petitioner. List this matter again on.
Date, my lord.
Huh?
Next week, any day.
Next week apni asylum court ki mana se. Mo saboli lab nai. Mo bisai thakute jai. Things up. 16? Ase? On 16/12/2025. Stop.
47.
Lordship, decision of POCSO case, Lordship, we have taken steps of notice
Huh?
on 28.
Okay, very good.
May I be allowed to submit my case first, Lordship? He has a right to object, Lordship, definitely.
Precedence to the petitioner to state his case. Otherwise, you will miss out something that you might have to require to be answered to. Yes?
Yes, Lordship. My case is wholly based on the non-compliance of section 47 and 48, Lordship. Apart from 30 days he is in judicial custody, Lordship.
Hmm.
Some photographs, the allegation is they tried to
take up some photographs
Hmm.
of the minor girl while
Hmm.
she was bathing. And when hue and cry was made, he ran away.
Hmm.
Mobile was seized. I am not aware whether photographs were captured or not. But I would like to draw your attention, Lordship, on the page 24, Lordship. At particularly page 25.
Huh?
Page 25, Lordship, 47 notice
Ah.
in Bihan, in the light of Bihan Kumar
Ah.
and the Praveen Purkash, Lordship.
Ah.
The grounds of arrested here, Lordship.
Hmm.
The accused is FIR named accused.
Hmm.
The victim is witness and identified the accused has given testimony against him.
Hmm.
If he is not arrested, he may commit further offences. The arrest is necessary for the purpose of investigation to prevent evidence, tampering, or influencing the witnesses. The accused person is an immediate neighbor of the victim. If he is not arrested, it may adversely impact the physical and mental well-being of the victim. What offence I have committed? Nowhere mentioned, Lordship, neither in 47 nor in 48, Lordship. This is the mandate of the Pravir Purkash, Lordship.
Mihir Ranjan Shah.
Simply.
Was it Mihir Ranjan Shah, the latest one? Mihir Rajesh. Mihir Rajesh Shah.
That has been confirmed, the Bihan Kumar and this Pravir Purkash, then
Anybody has a copy?
Yeah.
Mihir Rajesh Shah.
I have the Pravir Purkash, Lordship.
No, Mihir Rajesh Shah.
I have not the copy. Online I have there.
We need
Lordship,
one.
similarly, that has been.
We will need one copy of that.
No, I can give it within half an hour. Lordship.
Yes, half an hour.
Lordship.
Half an hour.
I have the Pravir Purkash, which is practically deals with this matter, Lordship.
Huh?
Pravir Purkash, the
Hmm.
meaningful part of this meaning of 47.
Hmm.
Not only mere service, but it must be in a meaningful way. And what was the offense?
That has to be said.
Started with the Pravir Purkash, the Lordship. The Pravir Purkash, the foundation judgment on this line.
Hmm.
And Mihir Ranjan Dev has confirmed it.
Hmm.
Then
Mihir Rajesh Shah, you
Yes,
you
the
get me the
Rajesh Shah.
Mihir Rajesh Shah.
I am giving you now.
There is one interesting aspect of it which we would like to discuss.
Lordship.
Yes. 38. Yes. Timing. লৈ আহিলে কপিটো তেওঁ জাজমেন্টটো লৈ আহিলে মাতি দিব. Yes.
Here in this case, Lordship, I am. And in fact, Lordship, I have.
A mention made in the morning would have eased matters for today.
Further.
You filed the objection without the CD. And the objection?
Yeah,
That is
one
what
thing
I-
I'm just pointing out before Lordship, that
Yes.
my main contention is that Lordship, that quantity which was recovered is intermediate quantity.
Huh.
So leaving apart that point, Lordship, my second ground is that 48 notice was not served on my relatives, Lordship. And in fact, their objection which I am having, Lordship, I am handing over a copy.
Hmm.
Just I'm sorry that I have marked it, but I'm just telling you, what they admitted that they have not given the written provision. So that admitted position, so why case there is, because that part Lordship may kindly appreciate. Paragraph 11 of their, 12 of their objection. There.
Unless it is on record.
Yes. Paragraph 12. They said that it is orally informed, so oral information will not do that, I'm not sure that all the judgment says, that it has to be in writing. So when IO is.
Now, how does someone inform, if all your family is in Rajasthan, how do you inform in writing right
They
now?
have to communicate through the concerned PS,
Huh.
but that grounds of arrest has to be in writing.
Yes, and it has to go to the concerned PS
Concerned
to
PS.
your relatives at home.
Oh,
So let the CD come, they may have some document to show that it was sent on a particular WhatsApp number.
no, the IO says, Lordship, it was orally informed.
The IO says that you are permitted to immediately inform the elder brother telephonically.
Yes.
It does not say that thereafter we have not sent the written communication.
So regarding, they have given the reply in respect to my petition also, where I have said that no grounds of arrest were communicated to my relatives.
Huh.
So in reply to that, they have said we have orally informed, that much.
No, orally informed, they have said.
Yes, that is what they have said.
They have said that they allowed you to make a telephone call.
Yes. So
But
apart
they have
from
not said
they
that we have not
complied
given
with
any.
48, they have not stated.
Therefore, let the CD be here Friday. Because that CD would perhaps Where is that 48? Where is that 48? Yes, you bring that, how you communicated to the, how did, how was he, the
Well,
fact of
never
his
signed.
arrest communicated to the relative? And what is this? Page 27?
Page 27, look at it. This is the order granting bail to the co-accused. On same 47 was not complied in that case.
Hmm?
47 was not complied in that case.
Same year, the family was not informed.
47 and 48 both were there. That
Ah.
lordship will find page 31,
In your case, it is only 48, not 47.
48.
এখন দি দিয়কচোন, তেওঁ দি দিয়ক। We'll list it on Friday along with the affidavit, objections filed by the, list the matter again on Friday along with the objections filed by the respondents and with the CD proposed to be produced by the learned counsel for the NCB. The learned counsel shall also have instructions as to the manner in which the family oblique relative oblique friend of the accused had been informed regarding his arrest and whether any written communication in any form was made. Full stop. See, we are making it very clear that day if you come and say that we are awaiting instructions, we are going to go by his version.
Outline.
49.
Your Lordship.
Yes, madam.
Lordship, is the bail application under 483 BNSS POCSO matter, Your Lordship?
Scan copy is awaited. 5/12/2025 says not received.
Lordship, I have annexed almost all the depositions here, also along with the charge and everything, and also I have.
A2, not received. Not received boli aise. Service report is also awaited. What about the service report? Oh, you are paying. Oh, you were there in another matter. Okay. Yes.
Lordship, FIR is vernacular is in page 20. May I read, Your Lordship? সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজি ইংৰাজীৰ 2/7/2025 তাৰিখে দুপৰীয়া অনুমান 2 মান বজাত মোৰ নাবালিকা ছোৱালী শ্ৰী দিয়া বিশ্বাস বয়স অনুমান 14 বছৰ উক্ত পদকীয়াজনে নানা ধৰণৰ প্ৰলোভন দি ফুচুলাই মোৰ ঘৰৰ পৰা অপহৰণ কৰি নি মোৰ ছোৱালীজনীক জোৰ জবস্তি শিৰত সেন্দুৰ দি বাল্য বিবাহ কৰায়। পদকীয়াজনে মোৰ ঘৰত কোনো মানুহ নথকাৰ সুযোগ গ্ৰহণ কৰি মোৰ ছোৱালীজনীক অপহৰণ কৰি লৈ যায়। পদকীয়াজনে মোৰ ছোৱালীজনীৰ লগত শাৰীৰিক সম্পৰ্ক স্থাপন কৰিছে। This is the allegation, Your Lordship. So, basically, what happened, Your Lordship, initially when we asked, when the accused person's family members asked for the birth certificate and the Aadhaar of the victim girl here from the victim girl's family, they provided us, that is in page 50, Your Lordship, a photocopy of an Aadhaar card where it shows that her date of birth is 28/12/2005, Your Lordship. So this was the photocopy given to us. The accused and the family members not aware that the victim girl was minor, Your Lordship. And
25 would mean
20 years, Your Lordship.
20 years.
20
And
years.
nowadays she's 14 years.
14 years. That is 2011 born. In the deposition also, she admitted that she eloped with the accused person as they were having some love affair. The 183 deposition is in page 23, Your Lordship. May I read, Your Lordship? As stated herein above, my name and address are true. I loved a boy named Raju Das. Thereafter, one day I eloped with him without the knowledge of my father and mother. After eloping with him, I got married to him at a temple, but no one saw us there.
After marrying, he took me to his home, but my father and mother then did not know. Thereafter, 2 days they got to know, but at that time they could not give the case. As such, I stayed with him for 2 months. In between these 2 months, physical relation happened between us. After elapse of 2 months, my mother went to the police station and gave the case. In between, my mother brought me home, but I again eloped with him and went to his home. As such, my mother gave the present case. So basically, by the 183 deposition, we can see that the girl was residing with the boy for about 2 months. But initially, the mother did not raise any objection. But later on, actually what happened, the scenario here is that the mother of the victim girl was again and again asking money from the accused for some monetary hardship thing. So when the accused could not afford that particular amount, then she went to the police station and lodged the present first information report, the present case. And thereafter on 31/7, on 3/7/2025, he was arrested. And on simultaneously on 31/7/2025, the case was charge sheeted, Your Lordship. So trial is going on before the POCSO Kamrup Metro. And also the victim and the informant has been examined and cross-examined and thereafter discharged, Your Lordship. Also in the informant's deposition, that is in page number 43, Your Lordship. 43, Your Lordship, informant's deposition, PW2. 43, 44 in the cross-part para 9, she also said that she has no objection if bail is granted to the accused, Your Lordship, as the case is charge sheeted. And all this is a love.
Para 9, I do not
Para
have
9.
any objection if the accused is released on bail.
Yes, Your Lordship.
Hmm.
But although bail petition was filed before the trial court, the bail petition was rejected on 31/10/2025.
You are appearing for? Yes, what do you say? Huh. Objection, they don't have any objection.
The accused person will abide by any condition of this put by this honorable court, Your Lordship. And as the
When were you arrested? July?
July 3/7/2025, it's almost
Yes.
159 days.
Mr. Goswami? Done. How many more people to go? The police? Is it not?
Three family members of the victim girl, more or less, one doctor and one IO.
So if the mother makes a statement in the court that I know that she eloped with the boy in the month of June, I did not do anything, should she not be behind the bars for allowing this? The parents of the boy, the parents of the girl, everybody should be behind. Why only against the?
After time, we have gave on the process, trial process.
Everything a waste of time. They knew everything. So why not a suo moto FIR against the mother and the father that you knew everything and you did not say it? That is one of the responsibilities under the POCSO Act. Anybody who comes to know that something has happened to a child, one is supposed to go and report immediately, failing which penal provisions. Yes, heard Miss So-and-so Learned Counsel. We'll let him go till the heard Miss So-and-so Learned Counsel appearing for the petitioner. Also heard Mr. So-and-so Learned Counsel appearing for the learned APP. Also heard Mr. Yug Ghosh appearing for the respondent number 2. It will have short of FIR the FIR was lodged on so-and-so that alleging that the accused had eloped with the minor daughter of the informant. Full stop. the statement, the case has been charge sheeted and the statements of the victim and the informant have been recorded and cross-examined also. Full stop. The learned counsel for the respondent number 2 submits that he is under instructions that there would be no objection to the accused being released on bail at this time. And in fact, in the cross-examination of the informant also, she has expressed that there would be no, she would not be objecting to the bail if granted to the petitioner. Full stop. Looking at the young age of the petitioner and the stage of the trial, where the victim and the informant have already been examined. Stop. This court deems it fit to grant bail to the petitioner. Full stop. Accordingly, the petitioner will be released on bail on furnishing a bond of rupees 15,000 with 2 sureties of like amount subject to the satisfaction of the trial court. Full stop. The following conditions shall also govern the grant of bail.
Deeply obliged.
Side us, participate in the trial. Yes.
483, my lord.
Yes.
But the CD was called for.
Received.
It is a matter, Roha Police Station, case number 129, 319, 316, 336,
Ah.
125, and 271. FIR at lawsuit will get a page. This is my
17.
type copy, 17. So basically, my allegation was the quackery practiced by the accused petitioner. That has been lost by the vigilance quackery prevention officer of the AMC, my lord. The grounds was that, my lord, I have used to use the, my lord, registration number 8118, my lord,
Mm.
as my registration number. That is a fake one. And second was that, my lord, I have shown in my letterhead description that I am a, my lord, PGD in
Postgraduate diploma.
gastroenterology.
Huh?
PGD in gastroenterology.
Mm.
And secondly, one SCG in gastroenterology. And I am prescription, I prescribe the medicine as Schedule H. It has been prohibited by the AMC.
Hmm.
But facts is this, when a lordship will come, the first one, that is the Annexure 1, this is my ID card. I am a valid doctor under my Ayush doctor. I am been appointed as a medical officer also under the government of Assam. This is a Mission Health Mission, my lord.
Mm.
This is an identity card. This is Annexure 1. And lordship will come to secondly, my lord, the Annexure 4. That is page 23. I have been arrested on 111. This is
On
my
111.
111. Now it is 39 days is completed. The offense is maximum is 5 years. My lord, so 60 days will be completed. So this is, my lord, this is my graduation certificate in the homeopathic, my lord, from the college
Okay.
concern, which is recognized under the Dibrugarh University. Second is, my
So
lord,
at least you are a doctor.
I am a doctor, my lord.
Okay.
There is no dispute, but they are saying that I am not a doctor. The registration number that has been not validly issued to me. That is not-
118 of 111 of 2
It is under the board of
111
my-
is under the
Board of
homeopathy.
my lord, homeopathic system of medicine.
It is not
It's
not
not
the
that-
registration under the.
No, there is a, my lord, 3 boards in the, my lord, medical practitioner. There is, my lord, one is AMC, another is, my lord, alternative medicine Ayush, and another board also for alternative medicine, my lord. There is 3 existing board, recognized board. So all doctors are recognized in different boards. So my registration is under that board. And
Ah.
moreover, my lord, the
And
lordship
what
will-
about that PGD?
Yes, well, I am coming to that. This is lordship will come. The next one, Annexure 6 at page 25.
And extra 6 page 25.
Yes, madam. This is.
Yes, you have been appointed.
Appointed as a medical officer.
Yes, yes.
So
No, we take it that you are
Yes, my lord.
you are a
Now,
doctor.
lordship will come to Annexure 8 at page 27.
Annexure 8.
Yes, madam.
Ah,
This is, my lord, advanced course in gastroenterology. I have validly obtained from this university, my lord. This is a correspondence course. And second one, lordship will get page 9, Annexure 9 at page 28. This is PGD diploma, my lord. This is also for 12-month course. But the
are these even recognized?
my lord, I am not aware of whether it is recognized or not, but this is just for, but lordship come to the next page. Annexure 10 at page 29.
Yes.
This is online, my lord, I have obtained.
Yes, sir. Behind bars. He's at least a homeopath doctor. He's
My lord, I am a valid registered doctor. I am
he's a
appointed as
registered
medical
doctor. He
officer.
would have otherwise practiced. Ah. Ah. No. No. Suppose today I say that my roll number in class 10 is N3 127. I hope no one is recording it. So it is N3 127. And you make a search in the SEBA and you find nothing. Arrested. Then you come to know it is from the CBSE, not from the SEBA. Does it become fake? Then huh?
Different body.
Assam Council of Medical Registration is, sir.
LMD.
Just a minute, sir. Have you heard of that allopathic doctor, homeopathic doctor, and this what is this called? Ayurvedic doctor. Allopathic medicines are not good. You should have homeopathic. This person is giving that homeopathic medicine, so he'll be registered under the homeopathic council, not under the allopathic council.
AMC, Assam Medical Council.
And he has given a registration certificate.
I am not.
True. The government of Assam has also given him this responsibilities under the National Rural Health Mission.
sir.
So doctor he is. Registration 1118 exists. Do you require him behind bars when there is no allegation that he has been prescribing allopathic medicine? Where is that allegation?
Another,
Huh?
just to answer one of the lordship from, this is made falsity, Apollo.
Yes.
But Apollo, University does not offer any such course.
Provide, but certificate courses provide. Certificate courses provide. They are. But my.
Certificate is also not recognized by LMC law.
Hmm.
Commission of India. It is also there.
This is a different angle. That will be looked after by different.
Why do you read him behind bars? That is what I'm asking you.
But
We are on a bail petition. Why do you require him behind bars is the only question, sir. And you will see that
my appointment as a medical officer under the National Health Rural Health Mission, my lord. I've been appointed working as a.
but
medical
then you were prescribing Schedule H
No,
drugs.
I am not, my lord. They have seized my lord, two seizure lists, my lord. Therefore, my lordship will not get anything that
The copy of the prescriptions issued by so and so to his patient has Schedule H medicines.
Yes, my lord. So to that extent, my lord, one letter also there from the director, this is registrar of the Assam Medical Council to the officer concerned who is lost the affair. That this can be only verified from the Board of Homeopathic System of Medicine. So he was advised to proceed to that authority.
Okay.
But he is not.
Yes, sir.
That's one thing, Lord. I need to know.
Ah.
One is clear, Lordship.
Hmm.
He also admitted that if she has come, she has given salary and also given allopathic medicine. So she has been showed by that,
Hmm.
but he has given.
So possibly it will be a case where you can apply for the cancellation of his license for not. But keeping him behind bars, you don't need to investigate anymore by keeping him behind bars, or that he'll come out and he'll prescribe medicines. No one will take medicines now prescribed by
There
him.
is such type of seizure is there.
Hmm?
Seizure is not there to that extent.
No,
And one
doctors-
letter also there from the.
From doctors, how medicines will be seized
No, no.
except the samples?
Well, the prescription, well, that is not, nowhere it is mentioned that the age civil medicine is there. And moreover, the one letter was from the registrar to the officer concerned to go to the,
But-
approach to the authority concerned.
Heard Mr. P. Mohanta, learned counsel appearing on behalf of the accused applicant, also heard Mr. So-and-so learned APP representing the state respondent, full stop. The CD has, you have the CD, na? The petitioner has been arrested on
On my 111.
1/11/2025 on the basis of an FIR lodged by the Registrar Assam Council. No, registered by the Anti-Quackery and Vigilance Officer, Assam Council of Medical Registration, alleging that the petitioner had been practicing as a gastroenterologist at Hira Medical Hall, Nagaon, where he mentioned his registration number as A1118 on his prescription letterhead. It was further alleged that the petitioner had claimed on his letterhead that he was a PGD gastroenterology and ACGE qualification from Medversity Apollo. It was alleged in the FIR that only doctors who are MD in medicine can apply and seek admission to the course of gastroenterology, which was a super specialty in medical qualification, and are given the degree of DM gastroenterology when they qualified. Full stop. Based on the aforesaid allegation, the petitioner was arrested on 1/11/2025 full stop. He has been suffering incarceration since then, full stop. The Mr. Mohanto, learned counsel for the petitioner, has submitted that the petitioner is a certified graduate in BHMS examination held in the month of October 2000, where he passed out from Dr. J.K. Saikia Homeopathic Medical College, full stop. The learned counsel has further stated that the registration number used by the petitioner is regarding his registration with the Registrar, Board of Homeopathic System of Medicine, Assam, Guwahati, and does not relate to the registration under Assam Council of Medical Registration, full stop. He says that the present, he submits that the present case is a case of mistake of the registration number, and therefore full stop. He has further referred to the certificates issued by Medversity Online Limited, where he had undertaken an advanced certificate course in gastroenterology and postgraduate diploma in gastroenterology, full stop. The counsel for the petitioner has further submitted that the petitioner is also appointed as medical officer within bracket Homeo for school health program in Dogaon, BPHC, Nagaon, by the to serve the National Rural Health Mission, Assam, full stop. He has therefore prayed that
Now posted at Bailabhura. Now posted at Bhurbanda.
the petitioner was last posted at Bhurbanda, full stop. The petitioner has, the council has therefore submitted that the petitioner may be granted the privilege of release on bail with regard to the aforesaid case, full stop. The learned APP has objected to the prayer by stating that the Medversity does not have authority to confer the degree, does not offer the degrees claimed by the petitioner, and therefore it is an apparent case where the petitioner has used used fake degrees on his letterhead. Yes. It is his submission, sir. We are not deciding it, huh? Full stop. The learned counsel has further submitted that there are some evidence where the petitioner has prescribed allopathic medicines, even though he claims to be a homeopathic doctor, full stop. This, he therefore prays that the prayer for bail may be rejected, full stop. This court has gone through the records available and also the case diary, which is received by the learned APP, full stop. Since it is not in dispute that the petitioner is a homeopathic doctor and is registered under the Board of Homeopathic System of Medicine, Assam, Guwahati. This court is of the view that the petitioner can be enlarged on bail. Accordingly, the petitioner would be enlarged on bail of rupees 20,000 with 50,000 of 50,000 with one surety of the like amount. Subject to the satisfaction of
CGM Nagaon.
huh?
CGM.
CGM Nagaon. Full stop. Conditions are the release on bail shall be subject to the further conditions 1, 2, 3, 4, 5. The petitioner shall not use the degrees of what were those degrees?
ACG and PGD.
During the pendency of the trial, and he shall also abstain from prescribing allopathic medicines if such prescription is not allowed
Lord, I may pray one
by
thing.
law. Yes.
The like amount that can be this way, because I have already given the 50,000, the like amount.
Then we'll make it 20,000, two sureties of the like amount.
That can.
Whichever you want.
50,000, that will be another 50,000.
20,000, two sureties of the like amount. He's a doctor, he can prescribe.
I'm paying again 37.
Yes, do we have a copy of that? Mr. Goswami, do you have a copy of that? Huh? Mihir? You should be tech savvy with the iPad. Mihir Rajesh Shah. Why is it Mihir Ranjan Shah? It is Mihir Rajesh Shah. Okay, can you come to para? 55. Para 55. Kindly read it. You have that copy?
Yes.
Para 55.
Yes.
It goes without saying.
So in that if the MP taking for supplying the grounds of arrest in writing is not adhered, the arrest will be rendered illegal and entitling the release of the arrest. On such release, an application for remand or custody, if required, will be moved along with the reasons and necessity for the same. After the supply of the grounds of arrest in writing, setting for explanation for non-supply thereof in the above is release. On receipt of such an application, the magistrate shall decide the same expeditiously and preferably within a week and submission thereof by agreement to the principal.
So when a sad face is made that, oh, technically now he will go free. Huh? Yes. Prospective meaning, we did not get you. It was decided on 6/11/2025. This was decided when? On 6/11/2025. So, if on a technical ground someone is, we have to set aside a custody after 6/11/2025. The possibility of your moving an application for, does it end? We are asking him, he said prospective. We want to understand. We seriously want to understand what was your contention. We want to understand that.
No, my arrest is after 9/11.
Huh?
Sri Darshan has-
What does it say? Hmm.
Demonstrable business is if he is not demonstrable business because of non-financing of the database, it is not the business, then as we will be.
Okay, we'll keep that in mind. We'll keep that in mind. Give us a copy of Darshan also. We can
Darshan has
quote.
distinguished by Honorable Division Bench of our High Court Lordship in a NIA appeal. Darshan has also been distinguished in Mansoor Ahmed case Lordship.
We will go to that. We are still on the bail part. Yes, your objections. Hmm.
Stop the,
Huh?
stop the victim also.
Hmm.
Captures video
Hmm.
while she takes bath in the bathroom
Hmm.
as well as outside.
Hmm.
Third, playing video, obscene video in front of her as well as attempts to show her the video. Fourth, this is not the first time he has been he has been accused of.
Hmm.
In the locality, he has been accused of other cases also. It is there also, in the FIR also. Other women and ladies have also accused him.
Hmm.
Other women or girls
Hmm.
have also accused of her other cases also.
When?
It is there also, in the FIR also.
In the FIR, yes.
Uh,
Show us the other allegations.
What are my instructions are there?
Hmm.
Lordship, in another case, Lordship, he is facing trial also.
Similar nature.
No.
There is another case. Another.
That is case of 323.
323. That is
323
for
Lordship.
judgment as well.
That is on judgment.
He is a habitual offender.
323 Lordship cannot be an
In,
immediate.
in any manner, in any manner connected with this case? No.
Not.
Hmm.
That is judgment of 12 Lordship.
Yes, sir. Show us the prejudice.
Lordship, Darshan Kumar is first not applicable, Lordship, that has been distinguished by Honorable Bihan Kumar is being a earlier in the point of time, Lordship. Our High Court specifically mentioned that part, Lordship, that Darshan Kumar cannot be applied. Then in Mansoor Ahmed, on fact, because that was a cancellation of bail. Darshan Kumar has come up on only on cancellation of bail. In Mansoor Ahmed, Lordship, that has been distinguished specifically, Lordship.
What we are trying to find out is this, sir. Yes. What we are trying to find out is this. Given the nature of the allegations,
Lordship.
leaving your mobile behind, all this together, can this court for a moment think that you did not understand why you are being arrested?
Lordship.
The writing skills of investigative officers will vary from person to person.
Lordship.
You are told that you are arrested because you are an named accused in the FIR.
Yes, Lordship.
When you are produced before the learned magistrate, remand magistrate, the learned remand magistrate states that you have been asked and you said you have the capacity to engage a counsel for your defense. But as you are not, you did not have a counsel on that day, the
That is the-
LAPC has.
Here, it is the demonstrable prejudice, Lordship. Had I been informed,
Hmm.
my relatives, they are of Guwahati,
Hmm.
they could have come and appointed an advocate.
Okay.
Lawyer has to be appointed either by the remand advocate,
A remand judge. Hmm.
through legal service system is there now.
Hmm.
No remand, no advocate. I can appoint a capacity. That is a different part, and appointing regarding having somebody, that is a demonstrable prejudice.
Now, was your,
Family members were informed,
Huh.
nor I was informed.
yes, when were information to the family members?
That is 48, same thing, Lordship.
Where is there? What
It
is,
is-
where-
it
what
is
is there? When was it done?
Page 26, Lordship, 27. Same thing. Page 27, Lordship, অভিযুক্তর
Page
নাম FIR
26.
অন্তর্ভুক্ত আছে. Even they were not informed why I was arrested. That's why I am relying on the reported case of Lordship, I have given the Prabir Purkayastha the case, Lordship. This is case to give you. Yes.
Are notice would be, are both starting notice 47 and 48, Lordship?
No, Lordship.
It is good. Because he, whenever I. If I to article 22 of the Constitution, that is why he has made a counsel for his defense.
When?
Article of this, article of this.
9/11/25 at 12:10 PM. And when were you produced?
9/11, Lordship. I have annexed the order of remand, Lordship.
Yes, yes.
May I be permitted to read the one paragraph of Lordship?
Please.
Prabir Purkayastha, Lordship, I have given the judgment, Lordship.
Huh.
Para 49.
Hmm.
It may be reiterated at the cost of repetition that there is a significant difference in the phrase reasons for arrest. Para 49, Lordship. And the grounds for arrest. As indicated in the arrest memo are purely formal parameters vised to prevent the accused person from committing any further offense, for proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in any manner, to prevent the arrested person from making insufficient threat or promise to any person acquainted with the facts of this case so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigating officer which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all the basic facts on which he was being arrested so as to provide him an opportunity of defending himself against custodial remand or to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated with reasons of arrest. Here in this 47 notice, as pointed out, Lordship, those may be the grounds of arrest. Those cannot be the, those may be the reasons of arrest, cannot be the grounds of arrest, Lordship.
We were happy when you said it was the ground of arrest.
I'm sorry for that. Those may be the reasons of arrest only, Lordship.
Barring one that you are a name accused in the FIR. That is
Name-
personal.
Name may be there, Lordship.
That is personal to the,
Name may be there. I am not, because copy of FIR was not furnished to the accused. As per the POCSO Act, copy of the FIR to be furnished to the victim.
yes, sir.
This is the constitutional mandate, Lordship, and continuously followed by Honorable Guwahati High Court, Lordship. I have another judgment of the exactly and similar case of the coordinate bench of this, Lordship.
This is called, for president, and he was produced before the trial. 9/11. And on 24/11, he has filed a.
Bail petition.
This is another, so, whether during that time, if he could file the application and he could get the bail, yeah, but he could not, because of that, not, that job.
Hmm.
Could not file application and in the bail, and he will be demonstrated. But here in this case, also when it person is called under POCSO Act, and he has filed his application in 10 to 12 days for 14 days. So, he is not, we cannot say also he is demonstrating in days.
It is the,
People not to say, not to. I just put right? It is said also that also if the person is file application soon after his arrest, if it is punished soon after his arrest also, then also it is also when person himself and what the most important is also he was interested, he was caught by the other person also. Then they informed the police and police came to him and we arrest him.
another point, I have not pursuing the issuance of notice of 35(3). This case is maximum punishable 3 years, Lordship. No notice under 35(3). Directly I have arrested. But as 47 grounds are available to me, Lordship, to my mind, 35, but that is also another, I have taken in my bail petition also, Lordship.
But when, so how can the reasons be given in this, in what manner? We are just trying to understand your argument. If these are only reasons, what
Yes.
will be the grounds that you had
No,
taken
FIR
the photographs?
FIR Lordship, that
Huh?
yes, these are the allegations against you, that are the grounds.
So that is the FIR.
FIR has not been given to me, Lordship. I am not entitled for FIR, Lordship. Within 24 hours, normally forthwith, it has to be sent to the court, not to the accused. There is no provision in the CRPC or the BNSS, Lordship, to give the.
Yeah, the
copy of
mobile was seized from the location or
No,
from
Lordship.
him later on.
Later on,
Huh?
later on, Lordship.
I think it was seized on the
Simple
spot.
allegation is I have fled away while I tried to show some videos. Hue and cry was made and I fled away. Case diary is available, Lordship, most of.
Huh?
No, that part is there. Facts, I am not arguing on the facts, Lordship. Purely my constitutional rights have been violated here by not providing the grounds of arrest, and I am entitled for bail as per the judgments, curtain of judgments of the Lordship.
Okay. Pass the orders later.
Lordship.
We'll have to see that part. That the judicial part, we don't want to go. Just-
Because if Lordship, I
Traverse
can
over it.
submit the judgment of Honorable, our division bench, Lordship.
Huh, please. Give
And
it.
Bihan Kumar has been given precedence over Darshan.
Bihan Kumar will have precedence over Darshan. Okay, we agree to that.
In this case,
but-
mostly, Lordship, I have given one judgment of Anup Kumar Patwari. Mostly in that case also, that judgment, NIA judgment was referred. I'm not-
Yes, yes, we've seen.
Anup
The
Patwari,
only thing that is disturbing this court is
I'm not sure, Lordship, that.
whether it can be said that you did not get the appropriate opportunity, that you did not even understand what happened.
Yes, Lordship. This is clear as it is.
You see, if it becomes a mere formality,
Not Lordship. Now it is.
does
not-
it become a mere formality?
After the Prabir test and this Pankaj Bansal starts from Lordship, now it not becomes a mere formality, Lordship. In Prabir, in a categorical words, it has been stated, Lordship.
We'll try to understand it on our own level.
Lord.
We'll do it tomorrow.
Finding item 61,
Oblige, Lordship.
supplementary list, item 61.
Item?
May I please, your Lordship?
Hmm.
Charged case, Lordship,
Huh?
commercial NDPS, in connection with the main accused, Lordship,
Huh?
Imjazul Haq already been analyzed on bail on 1st December, Lordship. I have the order by the coordinate bench, Lordship,
Commercial quantity?
commercial quantity. Already been analyzed.
Hmm?
On the ground of 47 and 48 violation.
On the ground of?
47 and 48. of the incident.
47 and 48, where is your ground of arrest? You are?
I'm not sure, Ramizuddin.
Where is your 47 notice? Huh?
32, Lordship. Last one is just. It starts from 29, please. And also, the notice 47 and 48 I'm providing by Imjazul Haq. who has been-
Have you noticed this ground of arrest? Yes, Mr. APP. The grounds of arrest, in most cases, we are finding exactly what Prabir Kaista say are reasons for arrest. Is it so difficult to understand? by the authorities.
What is the main request?
Hmm?
Same format, Lordship. Is my question.
Yes, what to do?
He has called for prevented and it is offense.
Still granted bail.
Why he has been arrested?
We understand. And yet, the bail has been granted. So this argument must have been made. It is one court, Guwahati High Court. There is no other court. There is one Guwahati High Court. This court orders. Courtrooms do not order, sir. Yes.
Both sides there are
Huh? Depending on the facts and circumstances of the case. That you can see. But one court disposed of, allowed. Same terms. ये हेरी लगा A to दिया से आपका judgment. 3607 to दिया से. When it is the same format, same FIR, we have to follow the same. Same FIR, same receipt.
Same out of 7.
Huh? Where? How? Show us. Huh? Page number 31. Accused persons are co-associates of the case. Then sufficient evidence is found. Then accused were actively engaged. Then accused is actively engaged. Then we have accused person is to be restrained. Accused person is to be restrained. One sentence here and there. Who? This man? So here the red-handed person has been granted bail based on the reasons of arrest being told to him. Same. No, the ভিতর ডিটেকশন ও বুঝাই ভিতর ডিটেকশন এটা বোর্ডখন শেষ কৰিলো
Published.
Bail hearing item 4153.
16 আছে না You are an interim.
Yes,
What
sir.
was the? What is the allegation?
Lordship, misappropriation of money, transaction of the bank. And Lordship, I am the Safai Kormi. I did not do anything because whatever the authority asked to me to do, I did. Otherwise, beyond that, I cannot do anything. And my statement was recorded already.
Huh? The statement is not there in the case diary.
My
Hopefully, he will not implicate himself when the case diary comes. Yes, Mr. So-and-so APP has submitted that the up-to-date case diary is awaited as required by the last order, full stop. Place this matter again in the January পিছলৈ দিয়ক অলপমান 20, 21, 22, 27 এনেকুৱা দিয়ক 27th of January 2026. The APP has submitted that the case diary has been sent back, but the updated case diary has not been received till now, full stop. Interim protection granted to the petitioner earlier continues. That is what I've said, that the case diary was received but sent back and has updated case diary has not come back.
I did.
Yes.
Maybe your option.
Hmm.
Case diary was called a number of times. Not come in the meantime.
You are on interim bail.
I am on interim, my lord. How many?
Let the case diary come since you are on interim. Service completed, someone appears also. Yes, You are the amicus. Any contact with the respondent number to know?
No allegation in affair also regarding that.
You are who?
He's
You are Abdul Kader.
Yes, madam.
Huh?
He's a brother-in-law of the victim as well as.
The accused is Abdul Kader.
Yes, and son-in-law of the informant. There was some misunderstanding because the victim went to another place where the petitioner decided to meet somebody else with whom she has come in contact with through social media. Thereafter, she contacted the petitioner to help her to reach her.
Where is the girl?
Girl is with the parents, man, now. Girl is with the parents.
Where is the girl? Where do you find that?
The scene now in government.
On the next step, Mr. Goswami, kindly have that instruction at least. Where is the girl? The FIR says he has taken the girl and he has not returned the girl.
But now the instruction is that he has returned back, parents have taken her back because she was produced before the police had done.
Where do we find it? Nothing.
I've stated in Facebook.
Huh?
It's para 4, my lord. The victim girl is now in custody of informant murder. I've stated in para case 4, my lord. That's fine.
And the FIR does not disclose POXO, does it? From which angle? My minor daughter girl has been enticed and allured by calling over phone by the above name accused. At present, he is absconding. Accused is my elder son-in-law. He is now giving various harassment to our house. He has not brought back the girl. Please recover the girl.
Instruction regarding.
The APP submits that. The case diary is not received, although on 27/11/2025 there was a direction from this court to issue fresh reminder for the case diary positively by the next date. You send the reminder or the registry sends the reminder? Then tell us that you have sent the reminders. Have you sent it? After 27/11? Yes. Huh? January 2? January 27, interim continues. Service report yet to be completed. Oh, he appears.
Yes, FIR your lordship will file at page 10.
Yes, respondent number 2, service complete. Yes, tell us.
Page 10 is the FIR lordship. And what thing lordship may kindly say page 11 is the part where it is registered lordship. That case is registered. The case is registered under section 18 of POXO Act, along with that IPC offences. In my humble submission lordship, that section 18 is not an independent penal provision. It has to come with any other offense, because if any other offense is committed, then section 18 will come. That may I take your lordship to section 18 of POXO.
পক্সোখন দিয়কচোন পক্সোখন দিয়ক না পক্সোখন আছে নে age of the victim is
At 14
14.
years at that point of time. And the boy.
whatever else.
Boy was 21 years
Ah.
of age.
Huh?
At that point of time, boy was 1 year of age, lordship.
Huh?
And they were having some affair which was opposed by the informer. Probably because of that reason, the present affair was lost.
Hmm.
And to my instruction, Lordship, now she is already got married with some other of her father's wish, as per father's.
Then your avenue lies elsewhere. Huh?
Lordship.
Your avenue would lie elsewhere. Provision for attempt to commit an offense.
Lordship.
Hmm.
Lordship, may I kindly see, whoever attempt, there,
Hmm.
whoever attempts to commit any offense punishable under this act or to cause such an offense to be committed, and in such attempt does any act towards the commission of the offense shall be punished with imprisonment of any description provided for the offense. So sentence will be as per the other penal provisions. So there has to be other penal provisions to attract section 18.
Hmm. So those have not been named in
So
the,
here, in this case, Lordship, if that section 18 is not taken into consideration, that for other offences, Lordship can grant me bail to face the trial. Lordship. That is my humble.
even if it is an offense under
No,
376.
511 is there, attempt.
Hmm.
Only attempt.
Attempt to
they will have-
376. Attempt to 376 is bailable,
So not bailable.
entitled to bail.
That lawyer Lordship can consider that as well because otherwise also Lordship, now she has already got married. Lordship.
Huh?
Already got married.
Yes, respondent number 2, victim. There was. Yes, Mr. Pal. Hmm?
In fact, if your Lordship sees page 17, that is the status of the accused, that is shown as status of the accused not arrested. It is not a case that I am absconding. Not arrested. Page 17 for a moment, Lordship, may I kindly see.
Yes, what do you say? Not arrested.
Yes, page 17. This is the copy of the charge sheet. In charge sheet, they have mentioned.
And there is no objection from the victim. She is now a major. When was the FIR lodged?
As in the year 2017.
2017 FIR not arrested till now. Why? And we are supposed to say that now he needs to be arrested. You have granted him the privilege of pre-arrest bail.
2023.
23rd charge sheet, 2023 charge sheet. Charge sheet has been submitted. You have appeared.
So I have.
No.
I have appeared.
You have been absconding.
That-
Oh.
There is a distinction between that. Lordship. Just
Please
that-
go and appear and pray for bail with all these facts there before the trial court. Why us?
No, Lordship may kindly consider this aspect, Lordship.
No, why
Page
us?
17.
Why cannot the trial court consider this aspect?
Because Lordship, if I appear there, I will be taken into custody.
Why?
Because Lordship, NBWA is issued, Lordship.
Why
may
you
kindly
and we? So the bail has to be for the NBW.
No, bail application.
I cannot recall it.
Even after NBWA issued, your Lordship can consider my bail application.
Huh?
Even if NBWA is issued, that Lordship application under section 482 is mandatory. That is mandatory. If it is mandatory,
482. This is under 482.
for granting bail, Lordship. 482. 480.
We allow him to appear till appearance, not to be arrested. On appearance, move an application. We'll go by then we'll go by that line.
till a certain period, I may be granted in the interim bail.
Till your appearance,
Lordship.
fixing the last date to be 15th January, lower court or trial court of January কেতিয়ালৈকে? 19th.
Any date, Lordship.
Appear before 19th of January before the trial court, NBW Captain Evans, pray for bail in the,
Till I grant the interim bail, Lordship. In that case, Lordship, if,
I'm not understanding the difference.
if it is kept in abeyance, Lordship, then the case will be decided on merit by the trial court. But if
Your bail
Lordship-
application.
If your
Yes.
Lordship grants interim bail,
Hmm.
Lordship, then he will be. Lordship,
On that day, he will appear and he'll be granted bail because
then he will face.
and
the
then we will dispose of the bail because the bail has been granted there and he gets to remain on bail.
That is what I am saying.
Then we are trying.
Lordship, my analysis page 7.
What was that? If you can't do it like this, do it like this.
Oh. We ultimately,
Huh.
Lordship, my analysis page.
The best
70.
deal for you, sir, is we'll grant you a bail till 20th of January, not 20th, 27th of January we'll grant it. Till 27th of January. Appear before that, pray for bail in the appropriate matter. If you do it before that, you'll still be on bail.
Lordship, that will be.
Is it not? No interim business here. Yes. Heard Mr. So-and-so Learned Counsel appearing for the petition. I also heard Mr. K.K. Parasal, Learned Counsel appearing for the Learned APP and Mr. So-and-so Learned Counsel appearing for the victim, full stop. This application under section 482 of the BNSS has been filed paying for grant of pre-arrest bail to the petitioner, full stop. The petitioner apprehends arrest in connection with. Yes, where is the detail?
That case number, special P, case number page 26, your Lordship will get it. Special P, case number 285 of 20.
Special case, page 1 ase, huh? So and so pending in the court of special judge, South Salmara, Mankachar, full stop. Perusal of the record shows that the FIR was lodged on
It is the laws down.
21/7/2017. Full stop. The petitioner was not arrested during the investigation of the case and the case was charge sheeted on 31/7/2023. Full stop. The case has been thereafter committed to the appropriate court where it is now awaiting trial. Is it?
Yes, awaiting trial.
It is awaiting trial, full stop. The learned counsel for the petitioner has submitted that by an order dated 16/12/2024, the trial court has cognizance was taken and since the accused applicant herein was not under custody, summons were issued to him, full stop. On 5/3/2025, a petition was filed showing cause for non-appearance and the matter was fixed on 26/6/2025 for appearance, full stop. On the failure of the petitioner to appear on 26/6/2025, non-bailable warrants against the applicant was issued fixing 15/9/2025, full stop. This writ petition was filed, this bill petition was filed on 15/10/2025, but the order dated 15/9, orders passed on 15/9/2025 are not on record, full stop. The learned counsel for the petitioner has submitted that the absence of the petitioner was inadvertent and for reasons beyond his control, and the petitioner is willing to participate in the trial proceedings if given the opportunity, full stop. In view of the submissions made, comma, and after hearing the learned APP, comma, this bail application, this anticipatory bail application is disposed of by directing the petitioner, by giving an opportunity to the petitioner to appear before the learned trial court on or before the 27th of January 2026, full stop. It is provided that till such date, the non-bailable warrants of arrest shall not be executed against the petitioner, full stop. The on appearance of the petitioner before the learned trial court, comma, he may move an application for grant of bail, which shall be considered on its own merits without reference to the present abeyance of the non-bailable warrants of arrest. Yes. Yes, sir.
If FIZ page 11, Lordship, the type copy, Lordship. Allegation of
Huh?
allegation of misappropriation of money, Lordship. Or founded, Lordship, informant is not come forward with a clean hand, Lordship. Is the person behind it?
How dirty is the applicant? Forget the informant. How dirty are you? Tell us that. When we say you, we mean the petitioner. Yes. Huh.
Informant, who has, Lordship, gathered those person, has mentioned that 40% he has gathered, Lordship. On condition-
Collected the money, handed over to you. Yes, why is the informant running free? Now, who collected the 40%? Informant. Attempt to corruption. Informant is also liable. No, he is depending on that. He is saying that the informant is not clean, so I need not be clean. Can he do that? What are the charges against you? What are the charges?
Yep, that's it. He made allegation that he has handed over as much as 30 lakhs 50,000 to the.
Accused threatened to kill me by shooting. Not returning the 30 lakhs is the allegation, or threatening to shoot? Which is the allegation? He and you kept how much?
Allegation is 30 lakhs.
He kept 30 lakhs 50,000. So we'll write a shorter order in rejecting him. 50 lakhs will be a larger order. You are appealing for? Informant. Yes, tell us, why did you collect money? Money to you.
And he has filed objection before the sessions court also, Lordship.
Ah,
I have annexed the objection, his objection, Lordship.
the money was for job. That they will give job. So that was corruption. You are part of it. Would you really like to object? This was a business which was good enough day before yesterday. Today the money is gone. It is not good. Huh? No, tell us, why do you need him behind bars? Just tell us that. Money not recovered.
Always we put them, they take the money, and then
When were you arrested? Yes. Some more time. And Mr. Parasar, the persons who are instigating these happenings, that will be bail rejected, disposed of.
Item 50.
Reflect his name also. What is your name? S. Ali, for the informant who had collected the money and handed over to the accused. Don't write that part, just write for the yes. এটা কি মাতলে? 50. Yes.
If the appeal against the conviction, this is the 5 years conviction under POCSO minor, and petitioner appellant is already behind bar for 1 year, 5 months and 8 days.
Hmm.
And
Some other day, or if you have got a very short point which you can decide right now, we can try.
Lordship, the petitioner is the headmaster of
Ah.
the school, and the victim is the class 4 student. There are 5 students only the class, my lord.
Huh?
There are 5 students only the class.
Hmm.
They, Lordship, and while victim was examined, and the student, 2 girls inside her was not examined, but she has both the girls says that he has no knowledge. If I can sort,
Now, what does the victim say?
victim says, Lordship kindly
Age of the victim?
age of the victim is 10 years, my lord. Class 4 student.
10 years.
10 years, my lord.
She has enough understanding to know what is going on.
Lordship. Lordship,
So other witnesses we do not know.
other witnesses, my lord, her friend, 2 friends examined, their cross part was also declined. They says, my lord, they have nothing to see.
Was declined.
Decline in both. And in fact, in the second bench, two students are there, they were not examined. In 5 and 6 is the friend of the victim, my lord. 2 students inside 5, my lord.
What? Page 37. No, we are only trying to look into it. If there is something very short, we can decide. We'll try to decide it because we will not go very deep into it today. Page 37. I for what? I have the main petition on my hand.
I am, my lord.
Where do we find her statement? Can we have her statement somewhere? What did she say?
There is a recorder on the comment.
Huh.
The couple of information we have.
Yes.
Yes, fine. Opinions of girls, class for girls, yes. But tuition, 164 to 10.
I think we can have it on some other day.
Lordship.
We'll have it on some other day. Age of the appellant is what?
Age of the applicant.
It's 56 years.
Hmm?
56 years.
Is it not aggravated? Why not aggravated? She was in the custody of that person. Huh? Is it not aggravated? I think it is aggravated. Has to be. That is there. Okay, okay. Okay. This part I think will come in. Whoever being on the management or staff of an educational institution. Below 12 years will be there. Oh, we'll have it some other day.
They've been 6 months.
When? Tell us. Immediately after vacation is heavily loaded. It can be on the after the 27th. Take it. 27th of January. Any day after 27th of January, your choice. 29th? At the request of the council for the parties, let's this matter again on the 29th of January 2026. Full stop. As a paucity of time may not allow a full hearing today. Yes.
Lordship, in this case, Lordship, I'm challenging the naming of charges.
Respondent number 2.
Yes, 56, Lordship.
Respondent number 2.
Lordship, respondent number 2, Lordship.
Huh?
Yes, Lordship, I have a prayer for interim because no case of rape is there, Lordship, no allegations. Subsequently, they have altered the charges under 376, Lordship. May
Where is
take
the
it-
FIR?
FIR on page 18, Lordship.
Page 18.
Yes, Lordship.
Yes.
Medically examined is only injury, assault injury, not any Lordship sorts of sexual assault or molestation, anything, no allegation of such nature.
Yes.
Lordship probably remember on the last occasion it's listed before this court, Lordship.
Yes, the case record received.
Case record
can
is
come.
there, Lordship.
Case record is there,
Yes, Lordship.
but in the absence of the,
That, Lordship, I'm to interim as an interim stay for the further proceeding, Lordship, as an interim. Lordship. And not for final disposal, Lordship, for interim, Lordship. Even the Lordship, the IR statement has been already recorded, Lordship, that is on page 54, Lordship.
yes, sir, what do you say?
54, 55, Lordship, IR statement is, he has
Mr.
been
Parashar?
cross-examined.
FIR does not say anything of that sort.
Not even medical, Lordship.
Huh?
Doctor has.
Then
already
where
been
is the
acknowledged.
medical?
Doctor evidence is there, Lordship. That is on page page 53, Lordship. And type copy on page 51.
161 came and assaulted me. পাছত সি মোৰ গাত হাত দিয়ে মাৰে. That intent is not there. Huh? That intent is not there. He মাৰে. And
Charge sheet was filed, Lordship, under section
পত্নীৰ গাত
94,
হাত
Lordship.
উঠায়. Then all kinds of slang.
Yes, Lord. Lang.
Then, yes, how does this 376 come in? Where?
No.
How has
ingredients
it
of
been
the
brought in?
Lordship.
Can you see?
375.
Only for the purposes of keeping it in abeyance still. Huh?
I'm for Lordship interim.
When is the next date?
Lordship, in the next date, Lordship, is the coming, that day, I don't, this month already, Lordship, fixed a date, Lordship.
This is, there is a sudden turn.
Yes, Lordship.
Have you seen? He মোৰ হাত দিয়ে মাৰে. Then suddenly the words are appropriately used to bring it into the, huh? When is it next?
Lordship, that day I do not have collected. Lordship. This
Collect it
month-
now. Collect it now.
Yes, Lordship, after some time, Lordship.
Ah.
After just, in the meantime, I'm, that
We do-
proceeding, further proceeding can be state, Lordship. Because 376 will not come, Lordship. I'm giving just, no, Lordship.
If you can give me the date, we'll either try to fix it before the next date, or
I'll
if it
just
is
give
too
you-
near, we'll try to have it.
Give me 5 minutes time, Lordship. I'll tell you.
I think you have got exactly 12 minutes. Yes,
Okay.
next to date.
I'll have it.
Item 52.
May I please refer?
Yes,
My lord, I on behalf of my senior, I Rafiq. Service report is with it.
huh? You are appearing on behalf of your senior and what do you want?
Service report is with it.
Oh. You have taken your steps.
Yes.
On respondent number 2. Await service report on the respondent number 2. List again after 4 weeks. Twenty-eight of what? January? list again on 28th of January, along with service report and CD.
53 and 54.
Charge sheet submitted, sir.
Proceed submitted.
The informant actually is the wife of the petitioner, my lord.
Yeah.
And as per,
Now, there are 2 petitions
yes, my lord.
by the same petitioner.
By the same petitioner, my lord. One petition is filed by my wife, my lord. That is item 54, my lord. 53 is filed by me, my lord, for question of the FIR. Same case.
Why has the wife approached?
Wife, actually, wife has challenged the order passed by the learned family judge,
Ah.
family court, my lord. Principal judge family court, my lord, whereby, my lord, the informant was directed to return back 13 lakhs rupees, which she took from me
Hmm.
as an amount of settlement, my lord.
Hmm.
Which
And
she-
why are you before the court?
My lord, kindly see, my lord, what happened in this case on 14/8/2025, my lord,
Hmm.
the learned, learned principal just family court number 2 has passed a direction to return back 13 lakhs rupees,
Hmm.
which the, respondent number 2 got from me as an amount of part payment of settlement amount, my lord.
Hmm.
After receipt of that amount, my lord, she has filed a joint mutual divorce petition, my lord.
Huh.
Now she is not willing to give the divorce to me, my lord. So, my lord, the learned court has passed that direction.
Who appears for? You are appearing in one item. Who appears on the other?
My lord,
Who's the petitioner on the other?
Mr. Pandya, I think.
Huh?
Mr. Chetri and Pandya is appearing for the item number 54, my lord.
54.
Pandya.
They are not here today.
My lord, what happened in this case, my lord?
Is there any interim prayer?
Uh,
Are you making any interim prayer?
no, I am at this stage not making any interim.
Huh.
Why, my lord? Kindly see, my lord.
No, no.
In
no.
item number 54, my lord.
Huh. He was required to refund the money.
Report.
You want the money?
No, my lord, kindly see, let me submit, my lord. In item number 54, my lord, the matter was again sent to mediation, my lord,
Hmm.
directing both the parties to appear before the mediator on 15/12/2025, my lord.
Hmm.
The report is to be submitted on 4/2/2025, my lord.
Hmm. It has.
So 26, my lord.
It has 4-2.
4/2/2026, my lord.
Hmm.
So, when we have subsequently filed this quashing petition, my lord,
Hmm.
Honorable Justice Kolita, remembering that order, my lord, where he has directed both the parties to appear in person before him, my lord,
Hmm.
has take both the matters, my lord, together.
So other matter is actually fixed for 4th of February 2026.
2026 for mediation.
4th of May for mediation report.
4th of
We'll keep
February, my lord.
4th of February. We'll keep this tagged with it on 4th of February.
My lord.
It has been submitted by the learned counsel appearing for the petitioner in criminal petition case number 1392 of 2025 that in the connected matter, that is CRP within bracket IO 403 of 2025, comma, there are orders of this court to list the same on 4/2/2026. Full stop. Accordingly, he prays that this matter may also be taken up on 4/2/2026
Along with, my lord.
along with the along with CRP IO 403 of 2025, full stop. Although both the matters are listed today, comma, none appears for the petitioners in CRP IO number so and so. Okay? Accordingly, list these matters on 4th of February 2026 as prayed for, full stop. Classic case of Mia Bibi Razi. You are creating all the confusion. The court has to take a decision. How can that be?
Supplementary item 62.
Hmm.
The fact I may not on the after three occasions this matter has been raised.
Hmm.
Now we are convicted under part 2 of 304
Okay.
for 10 years now.
Hmm.
Now we are pressing for an IA, my lord, for a bail.
Hmm.
May I allowed to submit a chart, my lord, which makes this absolutely clear. The entire records we are jotted down in a chart.
Hmm.
First submission, my lord, the appellant number 3 and 5, 4, perhaps. 3 and 4. There was no allegation, neither in the affair or in the evidence.
Yes, sir. Please continue.
Yes. Now, my lord, I'm just referring my chart, my lord.
Hmm.
The FIR was lost after 11 hours
Hmm.
of the incident.
Now, the FIR reveals three names who were not charge sheeted. Pulai Vishwas, Pinku Devnath, and Khalon Namasudro. They were not charge sheeted.
Hmm.
Now, the interesting point is the assault was, the disease was assaulted and he was rescued by the police
Huh.
and he died in the custody of the police. As per the autopsy report, he died at 6:20 PM on the day of incident.
Hmm.
And FIR was lodged on 21st next day.
Why did the assault take place at the road?
Now,
Any cause?
There are 5 differences
Hmm.
indicating the place of occurrence and the date and the time.
Hmm.
So for the PW1 is concerned, he said assaulted on road. And time is 12:30. Now Ravindra Vishwas, who is the eyewitness, so-called eyewitness,
Hmm.
he said as 10:30. At the house of Manik Vishwas, he is the appellant number 1. And another witness, PW6, he said 12 to 1 PM. And he said an interesting point that the disease was tied to the
This-
jackfruit tree.
This we will all look into, sir, when we take up the appeal.
And literally, I'm just
Here, you were. The judgment is of 27/6. You are behind bars?
27/6, my lord.
Huh?
That's fine, my lord. But the entire record says
Hmm.
one lady is in the custody. Putui Visha, he is not named by anybody. And on Roton Vishwas, he is also not named by anybody. The 3 witnesses, only eyewitnesses so far.
TCR is, do we have the
Yes,
TCR?
yes.
Do we have the TCR?
Yes.
The TCR is there. TCR received, then can we take it up on the reopening sometime?
I handed over, why I am handed over this charge
Hmm.
to my parliament friend, just to consult with TCR, whether the facts we have narrated here.
So instead of considering the bill today, if we take it up immediately on the next month, on a particular date, if since the TCR is here, we'll have the arguments.
Like 20th, my lord, January.
20.
Because the one lady, entire family is in the
We'll-
jail, my lord.
We'll accommodate you, there is no difficulty.
My lord.
This I has been
I-
filed, huh?
May I also,
Please.
unusual request,
Please.
if it is fixed at 2, my lord, because what happened, if it is comes to hearing list, it will now.
No, we will not, we will fix it on the 20th of January 2026. You are at liberty to make a mention in the morning
Fine.
that there are ladies involved and we would require.
May it.
If we are here, then
reflected in
we,
the order.
yes, this
Good.
IA has been filed praying for suspension of the impugned judgment and order dated 27/6/2025. An impugned judgment dated 27/6/2025 and order dated 36/2025 passed by the learned additional session judge FTC number 2, Tinsukia in session case number 52 within bracket CH/2021, whereby the appellants have been convicted under 341/342/304 within bracket Roman capital 2 bracket close /34 IPC and sentenced to rigorous imprisonment of 10 years and to pay a fine of rupees 5,000
50,000,
50,000.
that we must take me.
Full stop. And other sentences
The 5,000.
as shown in
No,
the
no,
order itself, full stop. The learned counsel for the parties are at consensus that this matter can be that the criminal appeal number 353 of 2025 may be taken up for disposal on 20th of January 20/01/2026. Since the trial court records have also been received, full stop. Accordingly, let this matter be listed on the 20th of January 2026, on which day the learned counsel for the petitioner shall be at liberty to make a mention for upgradation if required.
Grateful.
Upod likhibo heard Mr. So-and-so learned counsel assisted by Mr. Learned senior counsel assisted by Mr. So-and-so learned counsel and APB. Should we give both the names? Stronger?
No,
Yes.
I'm grateful.
Item 55.
This will require a very long hearing of 11 years. Huh? Still pressing it. Tell us, what was the amount of the check?
4 lakhs. 50,000.
4,50,000. Nothing paid back. Nothing paid back.
It is against the acquittal.
Huh?
It is against the acquittal, man.
You were acquitted. That is what I'm asking. Nothing paid back and acquitted, or because it was paid, therefore
No,
acquitted?
no, madam. On merit, madam.
On merit. Nothing you do, he should have checked and you did not get anything. What is your ground? Short.
Mainly, my lord, presumption was not drawn.
Presumption of?
Statutory presumption. There is a provision of statutory
Huh.
presumption under Chapter 13, my lord.
That it was in discharge of a lawful debt. Yes, that was not done.
That was not done. Actually, also some past findings are there, madam. But my lord, it may not be proper time for.
Some other day, we have to go for some other day. Paucity of time does not allow the matter to be taken up today. Stop at the consent of the learned counsel for the parties list this matter again on, yes, give us a date, we'll take it up.
Action it may be, my lord, because next.
When we say with the consent of the parties, then we need a date. On 30th of January. Stop. The appeal relates to, the appeal is with regard to the acquittal.
It may be taken up on hearing the matter on 29th.
29th, yes. Is that থাকিয়ে গ'ল নেকি?
Being item 51.
51.
That item, Lordship, I could not contact the and collect the exact date, Lordship. The advocate through whom I got that case, Lordship, is in
We'll have it on Thursday.
Thursday.
We'll have it on Thursday. Get us the date. Then we'll do at the request of the learned counsel for the petitioner who seeks some accommodation to inform this court about the next date of listing of the matter, full stop, a comma. List this matter again on Thursday. Short of it, huh?
Hello, please.
Yes, next. Should we continue or write paucity of time? Huh?
56.
Keta ase? Duta ase. Kori do. 2 matters only. Yes. Would you repeat the prayer you made on 13/11? On 13/11, you made a prayer to list the matter after some days.
I was in.
Yes, what is this I for?
For Lordship, Bay,
POXO.
POXO,
TCR ahile niki?
Section 10 of POXO and
The TCR is here, we can take up the appeal on a fixed date.
Lordship.
The due to paucity of time, this matter could not be considered in full today, full stop. The TCR has been received and therefore the consent of the learned counsel for the parties list the matter again on, yes, give us a date. Do you want a date or you don't want a date? Give us a date. 3rd of February 2026.
57.
May please, Lordship. In this matter, Lordship, positive. Morning, I have made a mention, Lordship, because one matrimonial appeal is also pending between the parties. Numbered as mat appeal number 75/25.
The learned counsel for the petitioner has submitted that there is a matrimonial appeal pending between the
being numbered
parties and there is a,
Being number 75/2025.
and there may be possibilities of settlement being arrived at. Full stop. Accordingly, both the councils for both the parties pray for listing of this matter after the BU vacations, full stop, registry to list the matter in the first week of February on a date to be fixed by the registry.
Lordship, interim order is there.
The interim order passed earlier shall continue.
Deeply obliged, Lordship.
Yes.
58.
Huh?
58.
May I please, Your Lordship? Lordship, may I pray for another dead, Your Lordship?
Huh? Huh? Hmm. So we'll take it up on Friday? We'll take it up on Friday at 2. Will you be available? At the, due to paucity of time, the matter could not be taken up, full stop. At the request of the council for the parties, comma, who submitted the, council for the parties, who submitted it is a short matter, comma, list this matter again on Friday. Full stop. Parties at liberty to make a mention.
Lordship, interim may be
The
continued.
interim order continues. When we said that at the consent of the parties or the prayer of the parties, the prayer is to list it for Friday. The prayer is not for the adjournment. We started with saying, due to paucity of time, I cannot take it up. Yes. And how is the echocardium ECG? It is fine. Thank you. Thank you.